last day. Both these matters have come. We have filed in the case of KNCD one including petition and a stay vacation petition, because unless that order is there, your lordship will not be able to do anything. So we may be allowed to bring in a record. And your lordship, I've already informed the Buddha Gugoi, the Standing Council of Medical Department, that this matter has to be taken up because today is the last day and your lordship is rising at 3:15 today. I think there is a reference.
Item 28 and
36, 36 of the supplement.
okay.
Your lordship will kindly accommodate us as per your lordship's judgment, because today is the last date of that counseling and we have taken out a judgment which will place it, it covers our case that it has to be proportionate and not only for unreserved. But we'll place all those documents. We have brought those notifications of the government of India also.
May please, Lordship. Lordship, I beg to
If
make
for some reason in the first of it is not taken, your lordship may kindly take it up at 2.
Okay.
Yeah, oblige.
May please, Lordship. Lordship, I beg to state a request for a matter listing tomorrow.
What matter?
The urgency is that the petitioners are above the age of 41, the grade 4 staff. There's an OM which has been issued by the technical education, which states that all grade 4 staff above the age of 40 will not be taken into consideration for temporary engagement. That is the only aspect of the matter that needs to be put before your lordship tomorrow. Because the GB is going to be sitting tomorrow itself in the Nalbari Polytechnic College.
It will be taken up in the second bench.
Absolutely, yeah,
Not
subject to your lordship's approval. I'm grateful.
Similar to your lordship, similar to your from the Nalbari Polytechnic, entire petition from the Karimganj Polytechnic, Budhur Engineering College lordship.
Please, your lordship. I beg to mention for listing of a motion matter for tomorrow, your lordship. Yesterday I mentioned it was allowed for today, but it has not come, your lordship.
Why?
It's service matter, your lordship. Yesterday I mentioned
What is the urgency?
urgency matter, my lord, in spite of government guideline as well as settled under this Honorable High Court, the private respondent is appointed in place of.
When was the private respondent appointed?
My lord, that is the private respondent appointed
When?
14th 11. 14th 11, your lordship. 14th November. My lord, therefore I filed representation before the authority, but they paid no
So
heed.
there's no urgency, it can come after the vacation.
Your lordship, yesterday it was mentioned and it was allowed for today, your lordship, but it has not come.
There's no urgency.
Clerical
Let it come out after the vacation. After
My lord,
vacation.
it is urgent.
There's no issue of now the private respondent has already been appointed on 14/11.
Yes,
He must have taken charge.
Yes.
Now there's no point. There's nothing. We'll take up on 3rd.
Third, your lordship.
Lordship, I like to mention item number 18. Here I have filed our affidavit. Lordship, we have sent it for vetting, Lordship. So we'll file it. I have already informed the petitioner. So let it come after vacation, Lordship. Item 18.
Okay, heard MS.
A. Sharma.
Learned counsel for the petitioner. On request made by Mr. SMT Chishti, Learned
Secondary education.
Standing Counsel, Secretary Education Department. Don't say letter. Mr. SMT Chishti, Learned Standing Counsel, Secretary Education Department. Submits that he is filing affidavit.
Yeah, I have sent it for vetting today, Lordship.
But-
I will file
but
it in the meantime. Let it come
affidavit
on.
has been sent for vetting. And press for some time to file the same. Praise allowed.
8 January.
Okay.
Oblige you.
May it please, your lordship. Lordship, I beg to mention for listing of a matter, lordship. Your lordship was pleased to direct listing the matter after 2 weeks, considering the urgency of the matter. Matter last posted on 25/11, lordship. Lordship may come immediately after vacation. Some
Yeah,
urgency is there.
After the vacation.
Another contempt matter, same.
Same thing.
May it please, your lordship. Lordship, yesterday I also mentioned this matter, lordship, for motion, lordship, but today not listed, lordship. Can it be for tomorrow, lordship? For motion, lordship.
It will be before the second bench.
Lordship,
It will be before the second bench, not before this bench.
Oh, I know that.
civil bench too, lordship.
Yes. That was.
Lordship. Oblige you. Mention it now. Oblige you, lordship.
May I please, your lordship? My lord, I beg to mention item number 13, my lord.
Yeah.
My lord, kindly adjourn the matter for the day, my lord.
Okay, on request made by
And Nasrin, my lord.
MSN Nasrin, Learned Counsel for the petitioner. Please have to winter vacation.
Oblige.
Lordship, I beg to mention item number 10, Lordship.
Yes.
Petitioner want to withdraw the withdrawal authority.
Okay, MS.
D Datta Lordship.
D. Datta, learned counsel for the petitioner, submits that she has instructions to withdraw this petition. Simple withdrawal. Mr. SMT Chishley
Lordship, kindly liberty Lordship.
with liberty to file afresh. Mr. SMT Chishley, learned standing counsel, appeals for the Secretary Education Department. With petition is dismissed on withdrawal with liberty as paid for. Yeah.
May I please, your lordship. Lordship, I beg to mention for listing, my lord, motion matter, my lord.
When?
Tomorrow, my lord.
What is the urgency?
Urgency, my lord, my salary has deducted for 3 months.
Why are you coming now? You come after the vacation.
I love this.
Sir, I will mention for listing petition, my lord, after vacation on 3rd January, my lord.
Okay.
May I please, your lordship, I beg to mention item number 11, lordship. I have instruction to not to praise the petition, lordship, as the matter has become in person.
MSR,
P. Kolita, lordship, on behalf of IH Borgia.
MSP Colita, learned counsel appearing on behalf of Mr. I.H. Baguria, learned counsel for the petitioner, submits that she has instructions to withdraw the present petition. Correct?
Yes, lordship.
Mr. S.M.D. Chishley, learned standing counsel, appears with the Secretary Education Department. With petition is accordingly dismissed on withdrawal.
Obliged.
Item 1 for motion. Item 1, Lordship, on last occasion, I have seen the last order and the Khatuna, he was supposed to, he has received an instruction and supposed to file an affidavit.
So this matter was listed on 19th of January 2024.
Because his mother is Lordship, he is,
And on
I
last
think he has not filed.
few occasions, they submitted that they have received instruction.
Yes,
They're
correct.
supposed to file it.
Yes, but because of his mother is seriously ill, he has not come to the court for last few days. And I think Lordship, he has not filed the affidavit. I have checked it, Lordship.
First week of
Any
January.
date, Lordship,
Okay.
immediately after vacation,
They
Lordship.
call it a counsel for petition.
First week of January. Lord.
Yes.
On request made on behalf of NJ Khatania, learned standing
10th
counsel,
of Friday.
Secretary Education Department. 2 weeks further time is allowed to file affidavit. List when?
10th of January,
Instead of 10th of 9th. Lord.
9th,
9th of
9th
January.
of January.
Right.
Obliged, Lord.
Item 2.
May I please, your lordship? Lordship, it's a content matter. Order of this court is annexure 3 lordship dated 13/2/2023 lordship. Kindly see the page 15 lordship, annexure 4.
Yes.
Lordship, Lordship, kindly page 18 lordship. The relevant portion is last 2 paragraph lordship.
When was the order passed?
Lordship, 3/3/2023 lordship.
What is the period of limitation?
1 year lordship.
Yes.
And lordship, within 1 year, I filed contempt case lordship. On dated,
This case,
yes, lordship, 8/2/2024 lordship.
this was filed on 8/2.
Yes, lordship.
No.
Lordship, like. Lordship. Annexure 4 lordship, kind,
How
page
is it
19.
that you filed on 8th of February and then it's coming up today? You filed on 8th of February. Correct.
Yes, lordship.
Why is it coming up today? Oh, was it in the defective section? Okay, hurt. MS,
D Datta lordship.
learned counsel for the petitioner, issue notice. Petitioner takes steps for service of notice on the sole respondent by release for CD within 1 week. List after 6 weeks.
Item 3.
Yes, Rani. Lordship, kindly peruse the relevant portion, lordships. Page 14. The director of secondary education shall release to the petitioner their pay 4/1/2022 as tutor. The pay of the petitioner, and since they have not been paid 4/1/22. shall be released to the petitioner by the director of secondary education within a period of 3 months. my lord.
Heard MSK, they will and counsel for petitioner issue notice. Petitioner takes steps for service of notice on the sole respondent by registered post city within 1 week. Least after
Item
6,
5 also similar order.
least after 6 weeks. Item 5,
Yes, my lord.
wait for your
Yes,
time,
yes,
it'll
yes.
come up.
Item 4.
May I please, your lordship?
Contempt
Petition, my lord, for non-compliance of order taken, my lord. Order is at page number, my lord. 8, my lord. Relevant portion is at page 10, my lord. Direction was to pass speaking order within 60 days, my lord.
When did you file this contempt?
My lord, 13/12, my lord.
Third MS,
SSDM, my lord.
SSZL and counsel for issue notice. Petitioner to take steps for service of notice. On the sole respondent by registered for 30. Least after 6 weeks.
Applies.
5.
Same day order?
Same order,
Yes, my lord, same order. Date is different, my lord. Page 12, date 21/3/2024.
okay, heard MSK, they will and the counsel for petitioner issue notice. Petitioner to take steps for service of notice on the sole respondent by registered post VD within 1 week, least after 6
Highly
weeks.
obliged.
6.
Yeah,
May I please, your lordships? This is a contempt application, lordships. Order of this court at page 18.
Hmm?
Page 18 is the order of this court, lordship, dated 6/12/13. Relevant part, page 21.
When did you file this contempt? 11, 12.
Page 21, paragraph 12 and 13, lordship, to the relevant part. I obtained the certified copy of subpoena same on 9/1/2024.
9/1/2024.
Yeah.
Okay, heard Mr. F.U. Barboyal and the counsel for petitioner issue notice. Petitioner takes steps for service of notice on all the respondents by registered post ID within 1 week.
Obliged.
After 6 weeks.
7 and 8.
Buyan,
My lord,
how are you?
my lord, recovering, my lord.
When did you come back?
Lord, on 17th of November, my lord, I was in Guwahati, my lord, then was a bed rest has been ordered.
Yes.
My lord. My lord, the petitioner was initially appointed as a lecturer, my lord, in the Department of Geography. My lord, may be pleased to find my appointment order is at page 21, my lord.
Of which writ petition?
My lord, the very first, my lord, item number 7, my lord, WPC 1956 of 2024, my lord. My lord, at page 21 is my initial appointment, my lord. Got it, my lord. This petition has been tagged, my lord.
Yes, okay.
Yes, my lord. Page 21, my lord, is my initial appointment as a, my lord, lecturer in the Department of Geography. On, my lord, may kindly see the date is at 22/12/2002. And accordingly, my lord, I did join in the state college. The joining report is also there. Now, my lord, as per at page 25, annexure 3, my lord, due to the vacancy arising in the state college, my lord, I was appointed as a principal of the state college by an order dated 28/4/2013 of Bhuragaon College, my lord, as per the resolution of the, my lord, governing body. And my lord, I have also been allowed to join in the said post on my lord 29/4/2013 at page 27. Now, my lord, what has happened during this course, my lordship is well aware, my lord, that the exercise for provincialization of the posts, my lord, of the various venture institutions were undertaken. And my lord, this college was also considered. And now, my lord, what has happened, though my particulars has been forwarded as a, to be considered as a principal, but my lord, that has not been considered. But my college has been, my lord, considered, my post has been considered as a lecturer, my lord, in the Department of Geography. So, my lord, I was remain unattended, my lord. My may be pleased to find my provincialization order is at, my lord, page number, my lord, annexure 5, page 45, my lord. Page 45 is at the very first serial number 1. And the name of the petitioner, my lord, tutor assistant professor geography, so and so had been considered. Though at that relevant period of time, I had been working as a principal, my lord. My lord, my only limited contention, my lord, is that, my lord, the as my post is required to be considered as a principal or tutor principal, my lord, that has not been considered by the neither by the DLC nor by the government, my lord. Therefore, I made the representation also before the authorities that my post should be considered as a tutor principal, my lord. But that has not yet been considered. Secondly, my lord, another move had been initiated by the government.
Where's your representation?
Lord, that representation. Lord, is at page my lord, 46. Immediately after the, my lord, provincialization, my lord, I made this 21/11/2020, my lord. It has been duly acknowledged by the office of the commissioner also, my lord. Secondly, my lord, without considering my this representation, my lord, the authorities at page 47 annexure 8 has also earmarked, my lord, my college, Bhuragaon College, that a new principal should be appointed by of a, my lord, fresh recruitment. Is at page 47 annexure 8. My lord may be pleased to find the name of the petitioners. College is also here, my lord, Bhuragaon College. Serial number. Bhuragaon College. So could be a lot of Bhuragaon College. So, my lord, this order had been put into challenge in a that petition is also taken, my lord, today. Along with this, my lord, what they have done, they at page 50, annexure 10, my lord, there is a move has been attempted to remove me, my lord, from the post of, because, my lord, what has happened, though I have been given the benefit of, my lord, a tutor assistant professor in the Department of, my lord, Geography, but I have also given the charge. Now, by the order dated at page 50, my lord, annexure 10, the authorities has decided to remove me and inducted another person as a, my lord, in charge principal. And this order had been put into challenge, my lord, by page 51, annexure 11 by WPC 5761 of 2021, wherein, my lord, the honorable court has pleased to pass an interim order is at page 53, my lord. My lord, this interim order is a till further order, status quo as regards the service of the petitioner as in-charge principal of Bhuragaon College shall be maintained. My lord, this interim order till date is operating, my lord. I have not been disturbed as this order has not yet been modified or vacated. But, my lord, what has happened? A move has been initiated by the government for the purpose of, my lord, removing this in-charge principal and by way of, my lord, a regular principal should be appointed. My lord, as my prayer for consideration of my case for the for extending the benefit to me as a tutor principal, my lord, it's still pending, my lord. So they can accept or reject, my lord. That has not yet been my prayer has not yet been, my lord, decided. So on the other hand, my lord, they have decided to go for a fresh recruitment. That is my grievance in this petition, my lord. So my lord can issue notice at this moment, my lord, if I can satisfy my lord, my lord.
But Mr. Yabrian and counsel for the petition. Issue notice. Says thus, the standing council higher education applies on behalf of all the respondents. Accordingly, notice on respondents are complete. However, extra copies, respondents are allowed to file a list. After 4 weeks,
Well,
in the other writ
Other
petition,
petition, my lord?
any order is required?
My lord, I think affidavit has not yet been filed, my lord. So, my lord, affidavit is required from the higher education, my lord.
Okay, heard Yabrian and the counsel for the petition in the other writ petition. Huh? Says thus, the standing council higher education prays for 4 weeks time to file counter.
well.
Praise a lot. List after 4 weeks.
Obliged, my lord, highly obliged.
Item 9.
May I please your lordship? My lord, I am appearing on behalf of respondent one.
Yes.
My lord, as per the instructions, the petitioner had actually applied for a scholarship under the name of post-matric scholarship for OBC students and not under the Ishan Uday Special Scholarship Scheme, which is basically the contention behind filing this writ petition, my lord.
Okay, nobody appears for the, none appears for the petitioner. MS,
S. Nath, on
S.
behalf of Dr. P. Agarwal.
not appears on behalf of Dr. B. Akawal for the respond number.
My lord, I am MS Nath on behalf of Dr. P. Agarwal,
Okay,
respondent one.
appears on Learned Standing Council UGC,
P. Agarwal, yes, my lord.
appears on behalf of the respond number 1. List after winter vacation.
I'm obliged, my lord.
12.
Well, now that is that investigation's case, my lord. Now it was fixed because the exam is going to be held on 28th of December, my lord. So she was directed in the place the affidavit or the verbal instruction. In the other, it was listed on the because of the urgency, my lord. 2024.
Where's the Guwahati University?
You can't have looked.
After some time.
Yes,
Oh,
ma'am.
okay.
14.
May I please your lordship? My lord,
Yes.
on the last order, my lord, the petitioner was directed to file additional affidavit. And to annex the document of provincialization order of respondent number 8, my lord.
Correct.
I have filed that, my lord, but the provincialization order of respondent number 8 is not available with us, my lord. I have applied for the copy, my lord, before the concerned authority, my lord, that is the inspector of schools, my lord. I have annexed that that application, my lord, but till yet it is not furnished to us, my lord. But my lord, I have obtained the data, my lord, which I have stated in my additional affidavit at page 41, my lord. In paragraph number 4, my lord, I have stated that. May I read, my lord? Yeah.
Okay.
My lord, basically, our pair is that, my lord. My lord, as per office memorandum dated 3/8/2021, my lord, at page 24, my lord. Of the petition, my lord. When clause number 15A at page 24F, my lord. 24F. The school having good infrastructure facilities together with an academic atmosphere and proper road connectivity in comparison to the other school shall be the base school. The senior-most principal headmaster shall be the principal headmaster of the school after the merger. As per this clause, my lord, the senior-most principal headmaster shall be the principal headmaster of the school. In the next, my lord, if the date of joining happens to be the same, then seniority in age shall be taken into
So the
consideration.
respondent number 8 was appointed as a headmaster in the year 2019.
Yes, my lord.
Why are you coming now?
My lord, recently, my lord, our school was merged, my lord, in the year 2023, my lord.
Then
Immediately, I have approached before the concerned authority also, my lord. My lord, what happened, my lord? If
yes,
you-
Sharma. Notice you go.
Yes.
Third, Mr.
A. Rashid, my lord.
Issue notice. Mr. U. Shamal, understanding council secretary education appears for respondents. 1. 2 also. 1,
2,
3,
3,
5.
3, 5.
Huh? Mr. G. Bekul and government advocate appears for the respond number 4. Finance. MS RM Barwal and outstanding council finance appears for the respond number 6. Extra copies. Petitioner takes steps for service of notice on the respondent 7 and 8 by registered for CD within 1 week. List of the respondents are allowed to file after. List of the 4 weeks.
Oblige, your lord.
15.
Chief, on the last occasion, instruction was forthcoming.
My lord, I pray for some more time, my lord. My lord, while communicating my lord to address, it should have been District Gwalpara, District Commissioner Gwalpara, but we communicated to the DC Bongaigaon. So some.
Heard MS?
A fine.
Learned counsel for the petition. Heard MS A Paying, learned counsel for the petition. On request made by G. Beku, learned government advocate. 2 weeks further time is allowed to receive instructions. Please. Winter vacation.
16.
My lord, that right of a professor to serve up to 60 years is 65 years the issue, my lord. And lordship was pleased to grant interim order of status quo. Now the state was supposed to file their affidavit, my lord, or to obtain instruction.
Any instructions, affidavit does?
No, my lord. Let this matter be come up after vacation, my lord.
Then we issue notice.
Yes, yes.
Better
Yes,
instead of keeping it in the motion stage. Heard Mr. K. Chowdhury.
One more aspect, my lord. My pay has also been not paid me.
Okay.
So they will pay the my current salary also.
K. Chowdhury, learned counsel for the petitioner. Learned senior counsel assisted by Mr. RM Deka, learned counsel for the petition. Issue notice. Mr. S. Das, the standing council higher education appears for the respondent number
1 and 2, my lord.
1 and 2.
And I am also respondent number 3 and 4.
Mr.
H. Chetty, Lordship.
H. Chetty, the standing council.
No, I'm on behalf of Mr. P.D. Nair.
The council appearing on behalf of Mr. P.D. Nair, and the standing council Cotton University appears for respondents 3 and 4. And Mr. C. Barwal, the standing council accountant general appears for the respondent number 5. Notice and respondents are complete. Do you require extra copies?
Yes, madam.
Okay.
We'll provide.
Extra copies. Huh? Respondents are allowed to file affidavit. List after
4 weeks, my lord.
4 weeks. Status quo order passed earlier to continue until the next meeting.
And my lord, there
On
was
the issue of the salary,
current salary.
Salary, my lord, death instruction I have to obtain whether it is.
But then by virtue of the status quo, I'm working.
There is status code.
In fact, my lord, Gordon-
We'll do one thing. I will not say list after 4 weeks. List the matter on, give a date convenient to you.
my lord, maybe on 9th.
List the matter on 9th.
Because the salary of
For,
Now, what had happened, my lord, there is a development. Cotton University has already written to the AG, my lord. Just I'm handing over this. এখন দিও না।
well, as per as like yesterday's case, my lord, Chandra Wari, my lord. The
Kindly similar with reference to this subject cited above and court present, I have the honor to inform
Okay.
you that Ratik will tomorrow.
what did I say? Respondents are allowed to file affidavit. Up to that only. Rest, cancel it. Mr. Ken Chowdhury and the senior counsel for the petitioner submits that despite the status quo order passed on 30/10/2024,
পাইছে আপোনালোকে নিলি।
the petitioner is yet to receive her salary till date. Stop. He also submits that the registrar of the Cotton University, by a communication dated 29/11/2024, wrote to the Principal Accountant General within bracket ANE Assam requesting for release of the salary of the petitioner with effect from November 2024. Correct?
Yes.
Till the receipt of payslip. Stop. Mr. S. Das, Learned Standing Council Higher Education, as well as Mr. C. Barua, Learned Accountant General, pressed for some time to receive instructions with regard to the salary of the petition. Accordingly, list the matter on 9th.
yes,
My lord, pendency shall not be a bar to release the salary. my lord.
Tendency shall not be about on the part of the respondents to release the salary of the petitioner. Status quo order passed earlier to continue. till the-
Deep level.
17.
In this case, well, instruction was sought for the last year.
I need some time to receive the instruction.
Heard, Mr.
S. Chauhan.
Learned Counsel for the petition. Mr. P.K. Roy, Learned Standing Counsel. P.K. Bora, Learned Standing Counsel, Elementary Education, press for some more time to enable him. Press for 2 weeks time to enable him to receive instructions. Press allowed. List after 2 weeks. Mr. B. Sharma, Learned Standing Counsel, applies for the Accountant General, Assam.
19.
please, George. The petitioner was a candidate for the assistant professor post in respondent number 3 college year. In the Department of Persian language, and there were three. They issued 3 notifications for notice your lordship. The first notice is at annexure 5, page 37. With relaxation of his age, his maximum age limit was 41 years, and that was covered at the time of first notification. Then, since he was the only petitioner, only candidate in that interview, the concerned authority has postponed the process, and thereafter another notification was here. That is in annexure 7. During this period also, he fulfilled the maximum limit of his age. Thereafter, what happened? COVID period started here. after period started, Your Lordship, what direction was came from the authority that is in Annexure 6A from the Director of Higher Education, Assam.
Annexure?
Annexure 6A.
Page.
6A. Page 38.
Yes.
When it was stated there in inviting reference on the subject I cited, I would like to request you not to publish any advertisement for filling up the vacant post of principal, assistant professor, librarian, and other non-teaching staff of your college until further order. Thereby, that was a stay, Your Lordship. After that, another notification was there, Annexure 6B, page 39, by dated 8 March 22. In this in this notification, it was stated that, with reference to the subject cited above, I am directed to inform you that the Government of Assam Higher Secondary Department has no objection to go ahead the already published advertisement for filling up the various posts of the colleges, but the announcement of the result appointment should be done after the period of enforcement of model of code of conduct is over. Thereafter, another notification was there for the same post. In this notification also, it is clearly stated that candidates who have applied in response to the earlier advertisement dated 29/12/2020 need not apply afresh. So the candidate did not apply the press application. His earlier application continued. Thereafter, he was selected and he was called for the interview. Page 41, Annexure 8. That is the calling letter. Interview for selection of Assistant Professor, Department of Persian. This is the calling letter, Lordship. He appeared in the examination interview and he was selected, Lordship. But later on,
select this.
No, though he was selected, but he was not informed. Later on, he preferred,
how do you know he was selected?
He preferred RTA petition.
Okay.
The RTA petition is page 42 to 43. And reply of RTO is also in page 44 to 67. And he was denied that only because of his maximum limit of age is exceeded. That is why he was denied of his appointment, Your Lordship. That is why the petitioner represented before the concerned authority, and the representation is at page Annexure.
When did you make your RTI application?
I made it on 14/8/2024.
When was the interview held?
Pardon?
When was the interview held?
Reply, sorry, Your Lordship. Application was made on 28/7/24 and reply was made on 14 August 2024. It is page number 68 to 69. Sorry, 44 to 67. These are the reply informing that I do not fulfill the maximum age limit.
Where? Page?
Let me go. Page number 66, Your Lordship. Page number 66. To the principal, SS College, regarding appointment of Dr. Sultan Ahmed, Assistant Professor, Department of Persian. In inviting a reference to the subject cited above, I am directed to inform you that you have submitted proposal for appointment of Dr. Sultan Ahmed as Assistant Professor in Department of Persian. The selected candidates for the post, but it is seen that Mr. Sultan Ahmed, the selected candidate date of birth is 7/2/1979, and as per the first day of the year 2022, his age is 42 years, 10 months, 23 days, which is above the required age for eligibility criteria for the post of for which the proposal is hereby regretted. This is the information made to us after preparing the RTA.
Hmm.
Now,
Yes.
now the notice itself says that whenever I apply for a post, the first date of that year would be calculated as my age, and at the
When was the first advertisement made?
first advertisement was made on the next of 5 years, see,
Yeah, page 37.
page 37.
What date
It was
is this?
the order was passed in 1610, and it was published in paper in 2019. At that time, I was very much within the period of the age, I mean, record age.
Okay.
And that very process of interview was continued after COVID era.
Okay. Yes, thus.
Look, notice may go, my lord, because as per page 62, the principal has addressed the subsequent to my lord, advertisement without seeking any permission from the higher authority. Then one show cause has been issued to the principal, my lord. So I have to take instruction whether that
But
is.
Mr.
B. Burman.
Learn the counsel for the petition issue notice. It says thus, then the standing counsel higher education appeals for respondents 1 and 2. Stop. Extra copies. Petitioner takes steps for service of notice on respondents 3 and 4 by registered procedure within 1 week. Respondents are allowed to file affidavit, list of the 4 weeks.
20.
Maybe. Under relating to area salary minute of suspension period, petitioner was placed under suspension in 2002, my lord. Thereafter, he was reinstated in his original
Where's
post.
the suspension order?
Yes, my lord. Your lordship will find page 21.
Yes.
This is the suspension period order, my lord. He was placed under suspension. Thereafter, my lord, after prolonged suspension, my lord, he was reinstated. My lord, your lordship will find page 23, my lord.
23.
23.
Yeah.
20. Type to my lord. Last 2 lines. My lord.
Hmm.
He was reinstated, and thereafter, my lord, after prolonged suspension period, his suspension period was regularized, my lord. Page 25, my lord. Last 3 lines.
Yes.
Thereafter, my lord, he was adjusted in his post, and lastly, my lord, the DO has submitted the proposal for arrear salary of the petitioner before the director. Your lordship will find page 38. Page 38, my lord. This is the forwarding letter, and next, my lord, statements. It was received by the Director of Elementary Education Assam 19/9/2024. Till then, it is pending, my lord. My humble submission before your lordships, my lord, at this stage, kindly issue the notice, my lord, and pendency shall not be barred to release the arrear salary.
But MS R. Islam, learn the counsel for the petition. Issue notice. MSS Jutiel, Standing Council, Elementary Education appears for the respondents
1, 2, 3, and 4.
1, 2, 3, and 4. And MS RM Barwal, Standing Council, Finance appears for the respondent. Notice on respondents are complete, however, exit of office. Respondents are allowed to file affidavit, list up to 4 weeks. Pendency of district petition shall not be a bar on the part of the respondents to release the error salary of the petition.
Obliged.
21.
May please, your lordship. The second round of litigation lawsuit regarding appointment and completion ground. The first order lawsuit will find at page 43. And after passing this order lawsuit, the district level committee has recommended the name of this petitioner and forwarded to the lawsuit state level committee. Lawsuit will find the lawsuit forwarding letter at page 47. Yes, lordship. This is the type copy lawsuit. And name of the petitioner has been forwarded lawsuit to the additional secretary government of Assam education department. So after lawsuit forwarding this name lawsuit, no communication has been made to this petition.
Yes, maybe.
That notice go, my lord, because that notification, my lord.
But Mr.
Jay Kalkal.
Non-counsel for the petition issue notice. Elementary S2TL understanding council elementary appears for 1,
3 and 5.
3 and 5, and Mr. J. B. Gould, Leonard Government Advocate appears for respondents 2 and 4.
My lord.
Notice on response complete, however, extra copies, huh? Responder all of file list of the 4 weeks.
Lordship. Obliged.
22.
May I please, your lordship? Lordship, my senior is in legs on another court, lordship. Kindly pass over the matter for the time being. Lordship.
May it please, there the petitioners are tutors, my lord, working in different ME schools in the district of Dibrugarh. What happened, my lord, some of the teachers, similarly situated teachers, they approach this honorable court. And the division bench of this honorable court, my lord, has passed an order, my lord. Lordship, but find that it page, my lord, 32. 33, the relevant portion is at page 44. My lord.
Yes.
Yes. But they are paying for regular scale of pay, my lord. And my lord, in a similar case, the division bench, honorable division bench has passed this order. Directing the state to, my lord, taking his steps to release to pay, my lord, the regular scale of pay. My lord, though the time limit has been given, it has to be done within a period of 6 months. It is there.
Is it over 6 months?
No, because the order was passed, judgment was passed on 4/10/2024.
Where in a hurry? This division bench judgment was passed on a different context. There the rules were challenged.
But,
correct.
Yes.
In the early ones, the rules were challenged, but
Yes.
then after the
Yes.
thing, the court
Yes.
said,
Yes.
no,
Yes.
they are entitled for, but then
Yes.
the government has given 6 months time
Yes, well,
to take a decision
Well,
and
well,
to go.
well.
That 6 months time is yet to elapse.
yes, well,
Why are in a hurry?
that is there, but the lordship has already issued it notice in some of the cases. Well.
How many weeks?
In one cases, well, 8 weeks. In other cases, 4 weeks. Well.
Okay, heard Mr. Emma Adigari, London Council for the petitioner. Issue notice. Chief Secretary, Mr. G. Baikul, and the Government Advocate appears for the respond number 1. MS RM Baro, Leonard Standing Council Finance appears for respondent 2.
Only 2.
And MSS Tutel, Understanding Council Elementary Education appears on behalf of respond 3, 4, and 5. Notice and response are complete. However, extra office respondents are not file after list after 8 weeks.
Well, how many?
24. This is a small matter. Last occasion, Karbi Anglong Autonomous Council was directed to obtain instruction. I am a retired government Grade 4 employee. I have received all the benefits except final pension. And the inspector of school Karbi Anglong has submitted the necessary proposal to the director of pension, page 17. When the proposal is under consideration, then page 22, last page. The financial advisor of Director of Pension wrote a letter to the Inspector of School stating that there was an excess drawal of ₹40 rupees from 1996 till the date of return. So, my lord, my humble prayer will be, since there is no provision for recovery of any amount from my pensionary benefit, direction may be issued to finalize the pension on the basis of my appropriate scale of payment. That matter can be disposed of, my lord.
May it please, so Lordship. Lordship, we have not received a copy. As like we
I have
could not
given the
take
copy, my
instruction.
lord, on that day itself.
It's not there. Its signature is also not there. I checked it. Extra
You are praying for?
KAC Lordship. Respondent number 3, I think. I don't have the copy, Lordship.
In any case, matter can be disposed of. There is.
Okay, I will
Yes.
be allowed to take instruction.
You serve for a copy?
Yes.
Yes.
Okay, heard Mr. N. Shamal and the constitutional MSH Tiram
Yes, Kempre.
S. Kempre.
Kempre.
Then standing counsel KAC prays for 2 weeks time to receive instructions. Praise allowed, list the matter after 2 weeks.
That may.
Then the counsel for the petitioner shall also furnish a copy of the writ petition to the learned standing counsel KAC within the course of the day. Yeah?
Be possible on date, my lord.
It will come up.
Yes.
25.
But on 9 Millard, it was directed to take instruction fixing today. And on Marine I have said there is no case for me, Miller. Only my prayer is similar. I have filed a reposition that will be disposed of. So
now, what is your case?
There is a maintainability issue in this.
That's why I'm asking.
For me, Miller, it is a bad case, Miller.
It's better for him to withdraw. Withdraw.
There is a prayer, Miller, annexer 1, there is a 5 million long back. That will be disposed of if otherwise, Miller, I have no case. I have seen.
You withdraw this
Yes,
petition.
it's better to withdraw, Lord.
Mr.
Yes.
Rashid Leonard Counsel for the petitioner prays for withdrawal of this petition. Mr. SMT Chishti Leonard appears. Leonard Standing Counsel appears for the second reading. The petition is dismissed on withdrawal.
And one thing, I may approach another from that may there may not be bar. Another from
Okay. Prays for withdrawal of this petition with liberty to approach the appropriate form. Huh?
Right.
Then under it is accordingly dismissed with liberty as wait for.
Must. 26.
Here, last order, I have seen that there is a direction to instruction. That instruction has not come, Lordship. Lordship may kindly give us a wait time, Lordship. Immediately after
Not a
vacation.
big amount also, it's quite a small amount.
Yes. I have seen it, Lordship. I have already
Leonard Counsel for the petition on request made by Mr. SMT Chishti, Leonard Standing Counsel.
Secondary
education.
10th of January, Lordship.
2 weeks
Friday.
time is allowed to file to receive instructions.
I'll make it positive.
On 10th January.
Yes.
Mr. D. Bhattacharya, Leonard Standing Counsel appears for the accountant.
Yes, sir. Copy.
You furnish a copy.
Smile.
7.
In this case, my lord, the petitioner, my lord, was appointed as a grade 4 employee of a ME school, my lord. Subsequently, my lord, a post was, my lord, assistant teacher was vacant, and he filed an application before the authority for upgradation of that post, my lord. And that was, my lord, forwarded by the authority, and my lord, the authority passed the order 1 21 to 2015, that is page 25 million. Page 25 million. Subject to revision at so and so without assigning any reason thereof, Sri Location Sahan is so and so is hereby promoted and appointed to act as an assistant teacher in the same school in the school of so and so. But my lord, it was alleged that my lord,
this permission, my lord, was made due to some, my lord, submission of some fake certificates. Then, my lord, lordship may kindly turn to page 26. His upgradation was cancelled. The promotion and appointment order made by this officer so to the post of assistant teacher in intermediate cadre in the same school is hereby cancelled. Subsequently, my lord, a case was filed, and my lord, that is my lord, Kheroni PS case number 106, page 30, my lord. Then, my lord, that my lord, his original post was also terminated, page 35, my lord. In pursuance of the letter so by Joint Secretary, is hereby terminated from his service immediately for submission of fake certificates. That was challenged before this honorable court, my lord. And this honorable court, my lord, passed an order on 19/9/2019, and lordship may kindly turn to page of 40, my lord. The awarded part, page paragraph 6, my lord. After hearing the parties and considering the materials on record, this court is of the view that since the petitioner has been already visited with the penal action of the cancellation of his appointment, and since it is not the case of the petitioner got his appointment as a grade 4 employee also by relying on fake certificates, but the said certificate was used only for the purpose of promotion, and since the petitioner claims to have been serving since last 24 years, even if the said termination order is not considered to be a case of double jeopardy, the same may be converted to that of the compulsory retirement, so that the petitioner may get some benefit. Accordingly, my lord, he was, my lord, got, my lord, compulsory retirement, and he has been, my lord, receiving the, my lord, retirement benefits, including the pension. Now, lordship may kindly turn to page 42. He has been acquitted by the trial court in the criminal charge.
Okay.
Thereafter, my lord, the petitioner filed a review petition before the authority, page 60, my lord.
Yes.
My lord, this review petition is, my lord, pending before the authority. So,
no, what review?
For review of the, my lord, original order of the, my lord, grade from grade 4, my lord. Because, my lord, earlier he was upgraded due to, my lord, it was found that, my lord, his upgradation was, my lord, due to some false documents. So he was, my lord, demoted to the post of grade 4, which was his original post. But since the criminal case, my lord, is, my lord, acquitted, so he filed the review petition for, my lord, consider his termination from the grade 4 employee.
Termination.
Termination.
How about this course order?
My lord, that is, my lord, page 53. The order, my lord, at page, my lord, 57, my lord, 56, my lord. In the criminal case, my lord.
No, this court's order.
Yes, my lord.
Giving you compulsory retirement.
Yes, my lord.
What happens to that?
Compulsory retirement has been given.
Then?
And now, my lord, since, my lord, he has been acquitted.
Supposing if they review the order, what happens to you?
My lord,
what happens to you?
My lord, if, my lord, because, my lord, grade 4 employee, my lord, he was, my lord, terminated because,
as per your representation,
my lord,
if the authorities reviews the order,
my lord,
what benefit will you get?
my lord, maybe given to, my lord, the grade 4 employee, my lord. Since
Then
he
what
has-
happens to the order passed by this court, judicial order, where you have been sent on compulsory retirement?
But it was since, my lord, the criminal case was pending, my lord, but
then this court's order will also have to be reviewed, isn't it? Or appealed against. You've accepted that, you've gone. What more is left?
after review, yes,
What more is left?
After review of that order, my lord. So, my lord, I will think about the matter, my lord. The matter may be adjourned.
Okay, on request made by Mr.
D.A.
Kayum, let the counsel for the petitioner list the matter after the winter vacation. You think about it?
Yes, my lord.
Because there's already a judicial order.
Yes, yes, my lord. Okay.
28. Let's 28 and 32, both will be taken together, man.
Pursuant to this order, what happens?
My lord, process is going on. Today, I think everything should be over. My lord, regarding the other writ petition, may I just point out one thing, my lord? If the writ petitioner does not withdraw the petition, then I think lordship will have to dismiss it with cost. Now, if your lordship would kindly take the judgment. কিতাপখন আহিছে নেকি এখন? 2023 volume 1 5 page 1 2003 23 5 SCC page 1. My lord, when this 103rd amendment was challenged before the Supreme Court, the basic ground taken was normally reservation is associated with social and educational backwardness. Economic backwardness could not have been taken as a criteria. Referring to Constituent Assembly debates and all, that argument was advanced, which was rejected by the Supreme Court. My lord, will kindly come to para 37 for a moment. At page number, what were the issues? At page 99. By a majority of 3-2, my lord, this amendment was upheld. And not only upheld, my lord, in fact, the locus of the social reservation beneficiaries under 15.4 and 5 and 16.4 was, my lord, rejected. Points for determination. 3 major issues to be answered in this matter by this bench have been noticed at the outset. In order to answer those issues and in view of the variety of submission urged as also subject matter, the following principal points arise for determination. As to whether reservation is an instrument for inclusion of social and educationally backward classes to the mainstream of the society, and therefore reservation structured singularly on economic criteria violates the basic structure of the Constitution. So this was the argument, my lord, that it is only social and economic backwardness which can form the basis, not economic criteria. 2. As to whether exclusion of classes covered under Article 15.4 and 15.5 and 16.4 from getting benefit of reservation as economically weaker sections violate equality code and thereby basic structure doctrine. So they are under this clause 2, my lord. 3. As to whether reservation for economically weaker sections of citizen up to 10% in addition to the existing reservation results in violation of basic structure on account of breaching the ceiling limit of 50%. So these are the issues, my lord. Now please come to page 177. Para 184, the conclusions. For what has been discussed and held herein above, the points formulated in para 37 and 38 are answered as follows. A reservation is an instrument of affirmative action by the state so as to ensure all-inclusive march towards the goal of an egalitarian society while counteracting inequalities. It is an instrument of not only for inclusion of socially and economically backward classes to the mainstream society, but also for inclusion of any class or section so disadvantaged as to be answering the description of weaker section. In this background, the reservation structured singularly on economic criteria does not violate any essential feature of the Constitution of India and does not cause any damage to the basic structure of the Constitution of India. B. 2. Exclusion of classes covered by Articles 15.4, 15.5 and 16.4 from getting benefit of reservation as economically weaker sections being in the nature of balancing the requirement of non-discrimination and compensatory discrimination does not violate equality code and does not in any manner cause damage to the basic structure. So the other day my brother friend was arguing, my lord, it is not compensatory. It is compensatory. 184.3. Reservation for economically weaker section of citizen up to 10% in addition to the existing reservation does not result in violation of any essential feature of the Constitution of India and does not cause any damage to the basic structure of the Constitution of India on account of breach of ceiling limit of 50% because that ceiling limit itself is not inflexible and in any case applies only to reservations envisaged by Article 15.4, 15.5 and 16.4. So my lord, on exceeding the 50% ceiling, two aspects were, two observations were made. One, it is not inflexible, and number two, in any case, this ceiling of 50 is qua-social reservation under 15.4.5 and 16.4. My lord, one more paragraph where the question of locus has also been considered, that your lordships will get in paragraph 144, page number 162. (144). Putting in other words, the classes were already recipient of any beneficiary of compensatory discrimination by virtue of Article 15.4, 15.5 and 56 cannot justifiably raise the grievance that in another set of compensatory discrimination for another class they have been excluded. So they cannot have the grievance, my lord. So this writ petition is, on the face of it, is not maintainable. Now, end of the day, my lord, a challenge was laid to the very constitutional validity of that amendment. Supreme Court has upheld. Now, my lord, therefore, and moreover, my lord, these petitioners, they have already got admitted. That statement is not forthcoming in their petition, my lord. My lord, if your lordship would kindly come to the other petition, item number 36, na? At page 2, my lord, of that petition, this Akshay Dole, he has already been given psychiatry, MD psychiatry. On All India quota, he has already got it. But there is no whisper in the writ petition. Similarly, my lord, petitioner number 2, he has got admission in MD pathology. Then similarly, petitioner number 3, anesthesiology, she has already got it. Similarly, petitioner number 5, MS ophthalmology in Silchar Medical College. Petitioner number 6, MD surgery, Assam Medical College, Dibrugarh. So, my lord, these are the petitioners who are already got admitted, but they have not made any statement in the writ petition subject to correction. Now, coming to our case, my lord, now the process is going on. Today, everything should be over, and the state is acting on the order. And today, I think they're likely to wind up the whole process. And subject to what my learned friend argues, my lord, I reserve my right of reply. So my humble submission is, my lord, their petition is not even maintainable. They have no locus.
Well, I'll try to refer to the judgment, because you can't pick up a particular line from a judgment and say this line will not be applicable to us, or this line will not be applicable to me. Other day, my learned senior friend has referred to the director of medical decision that it makes no sense. We'll try to understand what is sense in the decision. Secondly, he was talking about Chandrasekhar's googly. That day, I was bowled out googly because I did not prepare my brief, or I did not have the time to go through the judgment of EWS, which around 350 pages. Well, so far, let us go a little back. So far, the creation of the EWS is concerned.
One minute.
Yes.
On the item 22, 28.
Yes, ma'am.
You said you filed an IA.
Yes, we have sent.
I would like to file an objection to that.
Yes. We have filed it, my lord. We have already sent the requisition. It is on the way. It will come. But by the time it comes, I'll make my submission on the whatever the materials.
On the other,
whatever the materials are. It's only on law and pure mathematics. It's nothing. I'll stand that. Well, so far EWS as was concerned, EWS as was brought into the Constitution by Amendment 15.6. So far it relates to admissions in universities and colleges. 16.6 came, my lord, so far it is related to public employment and all those criteria. When a challenge was made that 15.6 and 16.6 was put to challenge before the Honorable Supreme Court, that Honorable Supreme Court never decided that what will be the seats that will be required to fill up the EWS case. Well, so far the reservations was concerned, prior to creation of that EWS seats was concerned, In Assam, it was around 33% because at that particular point of time in 2019, OBC had only 17%, 15%. Now it is 27%. As on date, my lord, the reservation category of so far Assam is concerned, it is 49.5%. OBC 27%, scheduled caste, scheduled tribe, total reservation is 49%, my lord. I'll give those statistics. I have made a table. Now, when this EWS was created, my lord, on the other day, if I have seen the video, a submission was made that the EWS is a vertical reservation. It's a horizontal reservation. It doesn't affect. Okay, but okay. But so far, okay. Well, so far, vertical reservation is concerned by this amendment of 15.6 and 16.6. This EWS is another vertical reservation quota. But the only catch was that in this vertical reserve category, no other reserve category like SC, ST or STPH, they can enter. It is only the people whose income is less than 8,000, who are 8 lakhs in a particular year, who has less than 5 acres of land, only they can enter into that reservation. Your lordship knows that Indushan is that Mandal Commission judgment. What that Mandal Commission judgment did was that they created a Lakshman Rekha, that reservation cannot exceed beyond 50%. That was the law till the decision of EWS. Now, already in some of the states, there were 49.5% reservation. So if you add 10%, then it will be almost 60%. So you are exceeding that reserve category of that Lakshman Rekha of 50%. So when this was put into challenge in the EWS case, which is my learned friend is referring, the first challenge of the reserve category candidate was that in the economically weaker section, that column, our persons who are economically weaker should also enter. Supreme Court said, no, you cannot enter into that EWS category because you are already enjoying some special compensatory reservation. The word compensatory reservation is applicable only in case of EWS, because the Supreme Court said that this compensatory discrimination is possible after the amendment of 15.6 and 16.6 of the Constitution of India. In this, so when it was 60%, the Supreme Court ultimately said that since Lakshman Rekha was created by judge, now by amendment of the Constitution, it can go up to 60%. Now, say, take for an example, if there are 100 seats. So earlier, 50% was on merit, 50% was on reserve category. Now, creation of this vertical column of 10% more. So ultimately, if the merit seat came to 40, then this hearing took place for more than 1 week in the Supreme Court. And two of my friends were arguing in that case in those cases. Well, then the submission was made by from the medical councils and all those universities and all on behalf of the government of India. See, now if you take 60 seats out of 100, because of this 10, the less 40 will only be available for the meritorious or the unreserved category. Well, in case of reserved categories candidates, what happens? Suppose in a scheduled caste, there are 10 seats in the medical college. 7 are filled up, 3 are not filled up. These 3 will ultimately go to the open category, merit. But in case of employment, if a job is not filled up due to the availability of the reserved category candidate, then it will spill over to the next year or the next appointment schedule. But so far, in admissions are concerned, it cannot spill over to the next year. It has to be filled up in that particular year. So the suggestion made from the Union of India, of course, this is not part of the judgment of the EWS that challenge on the Constitution. The Constitutional Court upheld 2 things. First, that this amendment of 15.6 and 16.6 is constitutionally valid because it did not affect the basic structure of the Constitution. Second, so far this compensatory discrimination which is created in case of EWS, here none of the scheduled caste or scheduled tribe candidates can enter. So how the suggestion made by the central government, which has later on came on the basis of a office memorandum, due to the loss of this 10 seats, which has gone to the economically weaker section, there was a submission made from the Medical Council of India, and which has later on came in the form of a notification that said, say there are 100 seats are there. Now we are giving you 10 seats for economically weaker section. So 40 seats are necessary. 40 seats only left. So the Medical Council of India, what they did, they said that we'll increase 25% of the seats of the total intake capacity in a particular year. And from that, we'll give the EWS. So that these 50 seats which were in the open category will not be disturbed. That is what the Medical Council of India has subsequently done. So this compensatory discrimination doesn't mean that this creation of this 25% additional seat will go to the reserve category candidate. It has to go to the EWS. I will take your lordship to those notification, because these 51 seats is, so far Assam this time is concerned, these are seats created exclusively to fill up this 100 plus 25. That 25%, these 51 seats are concerned. In all these years in Assam, my lord, every time the DME, I don't know why they don't do it. For every time to have this, to fill up this 51 seats of EWS, they have to come to the court. And although the National Medical Council says that you can go for this 25%, you can go up to 83. But they don't go it, maybe they don't have professors, they may not have the infrastructure, maybe in particular subject there is no demand in Assam. So they have confined only to 51 seats for this economically weaker section of the society. So normally what they have to do, they have to have, say, in the early years there was 289 seats, plus this 25%, it will come to around 333 and odd. From this 333 seats, they have to say that 27% goes to OBC, 10% to SC, STP, 10% to EWS, and all the other remaining seats will go to the open category or UR or unreserved or whatever be it. And if in particular category, some person doesn't take the seat or it is not filled up, then it will also go to the open category. This time, instead of doing this exercise, normally in the earlier occasion, people used to come, the student used to come before the first counseling. This time, what the DME did is that they did not add these 51 seats which are economically reserved for economically weaker section. As a result, they did the calculation only with the original allotment of seats of 280. As a result, what has happened, the general students, for general students also, from the general category also students, some seats were taken out and given to the EWS. Similarly, the other category remains. Now, after your lordship's order, these 51 seats, which has to be distributed proportionately, they have given everything to the general category. As a result, now the general percentage of general students reservation has gone beyond. So request choose not to. It's distracting. So now, because it's pure mathematics, I was not so good in mathematics in school. So now the general category students, their percentage has gone to 51%. I will show in the form of a table, and I will also refer to the various notification of the Medical Council of India, which says this 51 seats, when you give this 25% of the economically weaker section seat to the EWS category, the reservation percentage of all these reserve categories should not be disturbed. In this EWS judgment, I have read it in the last 48 hours for almost more than 300 pages. I have read it a number of times. I did not find that this seat should be given to the unreserved category. This was never addressed in the judgment. The judgment only said that this is constitutionally valid, 15.6 and 16.6, and the reserved category candidates cannot claim the seats of the 10% EWS quota. That is the judgment, and that is the what has been discussed. I can refer to that. It was a 5-judge judgment. 3 gave in favor, 2 was the dissenting. Dissenting judgment, some of the paragraphs are more readable than the main the 3 judges, but we have to go by the majority view. I have given a compilation to show the seat matrix. And I'm also compiling the various orders of both the cases for the convenience of the Honorable Court, so that I don't have to jump from one petition to another petition. Now, your lordship will look at page 1 first. Petition of just left. My lord, in page 1, my lord, this is the chart. I have given it here. This is the chart which is part of the first order. My lord, your lordship will find that order in the second case at the book is. My lord, your lordship will find that chart at page 60 of my petition at page 6812. Your lordship will see once. It's the same. I have, for the convenience of the court, I have taken it out and pasted it here. I have the affidavit, which is part. Your lordship will look at page 60. Your lordship got it, page 60. 60 of the petition. Of the petition. Of 6812. Now your lordship will see that the paragraph number 8 at the bottom. Accordingly, we are inclined to consider the passing of an interim order without expressing any view on the merit of the legal issues raised. For the purpose, we take note of the provisions of paragraph 58 at pages 56 and 57 of the affidavit in opposition of the Medical Council of India, where a number of seats subject-wise approved for an increase of the year 2020-21 had been provided. The said table is extracted below. Now, in the first column, your lordship will find seat available in the state quota is 39. Your lordship got it? Then in the second column, your lordship will find that reservation was 37% in 2019, because at that time OBC was 15%. Now it is 27%. So now it is 49.5 will come. That's why it is 37. But if you calculate 37% of 39, it will come to 15 seats. So 39 out of 15 seats will be reserved. Then 24 is for the open category. Well, same table. Now, if your lordship looks at 6 is the seats which I have said just now that have been created out of the 25%. So 25% that they increase in seats needed for implemented EWS quota is 6. Actually, if you calculate 25% of 39, it will come to 9 or 10 seats. But as I have the DME, he decided to give only 51 seats instead of 83 seats. So for medicine, he thought that I have only the infrastructure for 6 seats. That's why I will not give 10 or 9 seats. And you also will see the heading. Increase in seated seats needed for implementing EWS quota. Because by giving the 10% quota, you cannot take away the seats of the other reserved category candidate as well as the unreserved category candidate also. And if your lordship looks into the total in the next page at page 61, is 48. Then in the next page, your lordship will find 3. So this 48 plus 3 is the 51 seats which were exclusively reserved for EWS quota. Here the unreserved category, just like in the OBC creamy layer, cannot claim 27%. Here EWS quota, even if it goes to if the column is reserved for economically backward person, a person of forward caste cannot come and claim this 51 seats. Now, by virtue of your lordship's order, it has now gone to people who are even from the forward category. 51 exclusively to the unreserved category. Your lordship will see this is how the seat of 51 came into place. It was exclusively created for EWS category. Now your lordship will see the next document at page 3 of that compilation, because it has been taken out from the seat matrix. Last time I was not prepared for that googly. Now, but not at least I have to learn how to play the Chandrasekhar's googly. Your lordship will look at page 3. The brochure. Now your lordship will see on the left side category OBC, SC, STPS, STH, EWS, UR 40%. That will the total will be 100%. Now in the reservation percentage, your lordship will find 27%, 7%, page 3, 1-3. It will hit us a compilation purpose. Reservation percentage, your lordship will find 27%, 7%, 10%, 5%, 10%, and the 41% will remain for the unreserved category. What has happened in the third column, your lordship will find in the first round seats allotted in 2024, total seats was allotted 288. Now this 288 is without those 51 seats. That is what they have, the DME has committed the mistake. In the first round itself, if the 51 seats were added into the total, then this litigation would have not arisen. Now your lordship will see the third column. So far 77 is concerned, this is the 27% for OBC. Now 7% for scheduled caste is 20, STP is 29, STS is 14 seats. Now EWS 10% of the total seats will come to more. But here they were given 29 seats and one has gone to the vertical reservation to the physically the horizontal reservation to the physically disability quota. That's why it is 28 plus 1. Now your lordship will see the unreserved. Here, yes, unreserved when you give 119 and when they are entitled for 140, here you have taken away the 6. This 6 has to be returned. Out of 51 today, if you want to give them, then you have to give them 21 more seats, not the entire 51 seats. Because what will happen if you give the, your lordship will go for 5 minutes break as well. Is there?
Okay. Yes.
My learned friend is proceeding, it is going to take some time. In any case, in his case, notice has also not been issued. So lordship will examine the matter.
Let me please, because earlier there was a misconception about this reservation. Because last day I was also under the impression that this 51 seats, I will not go to a hog on because I have to place the correct facts which are before. Last time I was not prepared. So I will not take much time. I assure your lordship.
No, I'm not on that. I'm not saying, no, you can take whole day. I'm not on that. This for this honorable court. But otherwise, I'm saying, my lord, tomorrow is the last working day. Today also have got so many matters. If it continues like this, it will become.
No,
Lordship will issue
to
notice and fix the matter immediately.
No, I have a prayer for interim because by this, once the seat has been allotted, then I will be not, then no purpose will serve.
According to the other side, you have already been admitted.
No. That's wrong. The only allotment was done.
It's a writ petition. Candid disclosure of fact is a sine qua non.
No,
Why there is no statement that I have already admitted?
No.
In KD Sharma, Supreme Court says such a petitioner should not be heard. What disputed? We have got information. So we'll file affidavit then.
You file it, but let me place the facts before your lordship. I will not go into this disputed questions of
my
facts.
learned friend's contention eventually, if it is to be accepted, well, number one, the Supreme Court judgment will go for a toss. And secondly, my lord, it will come back to the same position. If that increase is to be added in the overall thing, then my lord, same thing will emerge.
My lord, your lordship will see from this page 3, I will satisfy.
No, these are all your figures. These are not figures of the state government.
These are figures from the record. I will show it. I have already compiled it.
I have just pointed out, my lord, I don't think as per para 144 of the Supreme Court judgment, you don't even have locus standi to challenge this.
No, my lord.
Since you are a beneficiary, under 15, 4 and 5.
No, you are taking away my benefits. That's what I'm showing.
Nobody is taking anybody's benefits.
See the document number 3. Let me conclude, my lord. We cannot go on piecemeal basis, my lord. Let me conclude. I assure your lordship will fix the time within which I have to finish. I'll finish it, my lord. I assure this lord.
Okay.
Anyway,
Yes.
I'll take lordship's leave for some time.
He has some motions matters, but let him go, my lord. I have no objection, my lord. Your lordship will look at page 3. What actually is the ground reality and what has happened after your lordship's order. Now, if your lordship looks at page 3, say for example, OBC. OBC is 27%. Then we are given 77 seats. These 77 seats were given out of 288 at the bottom. Whereas the total seats, if you add the 51 seats, it will be total seats will be 342, last row. 339. If you round it off, my lord, 339 will be the seats allotted after rounding off. At the bottom line, my lord, your lordship got the 339 figure?
Yeah.
Total. Now, if the total seats instead of 288 would have been 339, total seats we would have got was 91. Correct, my lord? At the top, OBC, 91. Seats to be allotted after rounding off is 91. Since they did not add these 51 seats to the EWS also took from us, my lord. That's why 91 minus 77 out of these 51 seats, which the EW has taken from us in the first round. Then if we get this 14 seats now out of 51, then only the percentage of 27 will maintain. But out of this 51, your lordship will find in the second last row, no seats have been given. That's why our percentage has gone down from 27 to 22.71. Just like all the reserve category, even the EWS will suffer if the 51 seats is given only to the unreserved category. Your lordship will see OBC's percentage has gone to 22.71. SC is gone to 5.8%. STP has gone from 10% to 8.5%. STH is gone from 5% to 4.1%. EWS has gone from 10 to 8.26. How, my lord, your lordship will see? 10% EWS cat line, your lordship will see 29 seats they got, whereas they ought to have been given 35 seats. So 6 seats they have lost As a result, they did not get this 8.26. Their percentage gone down from 10 to 8.6%. Now, in case of unreserved category, yes, unreserved category has also suffered when seats were taken and given to them to the EWS category. It's not that only seats were taken out from the EWS from the unreserved category and given it to the EWS category. Your Lordship will see the unreserved category, total seats is 119. Your Lordship got it in the table, my Lord?
Yes.
Now, if your Lordship see.
1 minute.
Yes. Page 60 was the page.
Yeah, where is the council NMC?
NMC is here.
And medical?
Now, your Lordship will see again at the table, my Lord.
Have you got copies of this?
Yes, we have given the chart to them in the morning. And these are all from the records only, just for the convenience of the court. This mathematics, if you do it here, it will take more than 1 hour. That's why I have compiled it for your Lordship's convenience only. This is simple mathematics. Now, in case of unreserved, my Lord, what has happened? They were supposed to get 140 seats and they were given 119 seats. Yes, that's why out of 51, if you now out of 140, if you are given 119 seats, then 21 seats you are entitled to get from those 51 seats, my Lord. This is plain mathematics, my Lord. How can they be given the entire 51 seats as a result, which their percentage has gone more than 50%? 50.47%, my Lord, in case of unreserved category. So our contention is that out of these 51 seats, 21 seats should go to unreserved, 6 seats to EWS, STS 2, STP 5, SC 3, and 14. In the earlier, what has happened, my Lord, before I take to the orders of the court, earlier court has directed only to the DME to do all this calculation. This time I have seen the video during the motion stage. Well, much stress was put on the word unreserved to be included in the order without presenting these facts properly, my Lord. Because if these facts were presented on day one, your Lordship will not take give a direction that 51 seats has to be given only to unreserved category.
NMC, what do you have to say?
With this regard, my Lord,
Is the
also earlier orders, my Lord. Earlier orders, it was distributed overall. But however, my Lord, this time around, Lordship order is very clear that this has to be given to the unreserved and this was a compensatory measure. My Lord, I have spoken to the department as well. But to say that yes, to the aspect and to the extent of my Lord allowing the seats, only till there the NMC has a say and a role, my Lord. Once that a certain amount of seats is allowed, how, my Lord, those seats are allocated and amongst which categories those are divided, that is the prerogative of the, my Lord, the DME and the State Department under the, my Lord, judicial intervention of this honorable court.
Yes, go ahead.
My submission included a super as far as earlier out of litigation are concerned. Orders passed by the court and based on the court. Every year, days to come. There, 51 seats are increased pursuant to orders of the honorable court, and it is divided. Apparently, the charge itself is put in the order. So those are part of the I also of the institution. That was there. But this time,
it is divided amongst all.
All.
Proportionally. 50% like go to the unreserved category, 50% will remain for the reserved category.
And your loss.
Proportionality will have to, because again, the unreserved category also they cannot go beyond 50%.
Correct.
So that will have to be maintained, and that only the authority, the counseling.
But why were you keeping quiet on the other day when this court was passing the order?
My Lord, he was not there, my learned friend. I have seen the video, my Lord. If he was there, my Lord, this order unreserved would not be specifically mentioned because we did not have the assistance of Buddha Gogoi on that particular day. I've seen the video number of times. This unreserved word was stressed because they won the 51 seats. I am not saying that injustice has not been done to the general category students because they are entitled for 114 seats. Out of that, you give 119. So you are entitled to additional 21 seats. But you cannot have the entire 51 seats because this will have far-reaching consequences amongst all the medical students, including all over India. This order will be cited as a precedent that this excess seats which are catered for EWS will go to only unreserved because the Supreme Court has created this 10% EWS, this excess seat of 25%. In Assam, it is 51. These 51 seats have been created only for the EWS so that the total seats which are remain for the merit will not be disturbed. And this discussion is not part of that constitutional bench judgment. It is due after this administrative order. Your lordship will just for a glance see the order at page 4. Next page, my lord. This is the order given by the Secretary General on 29th of January 2019. Now, if your lordship looks into the next page at page 5, these were never placed before your lordship, my lord. Page 5, your lordship will see first paragraph, 4th line. At any stage of implementation of EWS reservation, the number and percentage of reservation provided for SC, ST, OBC categories shall not be reduced. By this exercise of 51, you are now reducing the percentage of all the categories, and you have increased. Now your lordship will see another communication at page 7.
Yes.
Now at page 7, your lordship will see the first line. Guidelines for calculating additional seats for implementing 10% EWS quota. Initially, it was MBBS. Now it is applicable for the PG also at page 7. Now your lordship will see the 3. In order to implement the 10% EWS reservation quota, the increase in seats has to be effectively 25% of the current intake to ensure that the existing number of general and other quota seats are not affected. Thus, a college with current intake of 100 seats would need to add 25% of additional seats, that is 25. So, to implement the 100, you have to increase another 25 seats for EWS. Because ultimately, merit had that compartment has reduced, no doubt. Because here also earlier, because of 15% reservation for OBC, merit seats was more. Now 27% has been increased. And that 27%, the Supreme Court, Honorable Supreme Court in one of the judgment has said that the Osuka's case, that this 27% which has been made for OBC, in spite of not quantifying data and all, but constitutionally valid, the Supreme Court has said. So this 27% has to be given to the OBC. For giving it to 27% to OBC, there was no direction to create additional seats, unlike in EWS. Because EWS is a very people who belong to the lower economic strata of the society. That's why SC, ST, they were not given entry into that. Now your lordship will see 4. The calculation of seats has to be made taking into consideration the total intakes of students at the state level, considering all the seats institution where the government reservation policy is applicable and is being implemented. So you have to take the total intake capacity. This 288 plus 51, that is total will be around 339. You have to take the 339 and divide the reserved category. Now your lordship will see the format at page 9. Annexure 1, page 9.
Yes.
Serial number, how to calculate the increase, name of college, seats recognized or permitted for 2019-19, that is the complete seats. Then out of that complete seats, 25% has to be created additionally. 3rd column. Then your lordship will see page 10. The example was given by the medical council how to do this exercise, my lord. Next page, my lord. Page 10. Your lordship will take the serial number 10. Say state Assam. If there is 100 seats, my lord, at serial number 10 on the left hand side, my lord, serial. If there are 100 seats, if you increase by 25, it will be 125. Now you have to create this more 25 seats. But NMC says if you want to admit more 25 seats, you can even ask from up to 150 seats. That's why in case of Assam, although 51 seats are required, the NMC has said that you can ask for 83 seats. This is how the formula works, man. Your lordship will see the 1, 2, 3, 4, 5th column. Total number of seats after inclusion of EWS quota, 25% increase, that is 25. This ought to have been done in case of Assam in the first round of counseling. All this problem has arisen because on the first round it was not there. On the day when it was motioned, we are lucky that it was not disposed of. Effort was made to get the petition disposed of in the day one itself. But your lordship has issued notice. That's why we had this opportunity to come and address your lordship. That this 25 additional seats which was created for the EWS has to be, since it was not taken into account on the first round. And because of that matter, all the categories have lost seats. So for this 10WF, they are now have to be compensated back those seats. Otherwise, their reservation intact percentage will go down. Your lordship will also see the other formats also at page 12. Page 12. Your lordship will see the right-hand column, number of seats to be increased in 2022. These are all given by the format. Then in the pro forma 2 also, your lordship will find that you have to calculate that 10% seats after taking into consideration the entire intake of a student in a particular year.
Gogoi, what is the stage now?
Regarding this, may I clarify only one document I will clarify. This will clarify everything. May I have a look at my W60 6640.
66. 1 minute. Yes.
Page 38 document
Yes.
This is regarding clarification regarding available seats for completing after implementation of EWS data in the MBPS code. What you will see the para 2. One is regarding increase of seats. Para 2 says it is further clarified that the increase in seats granted to implement 10% EWS quota will be part of the total MBPS seat available for admission. And all the various quotas like all India quota, state quota, including EWS, SC, ST, OBC, and other reservation, will apply to the total MBPS seat. So I think this clarified. It will be part of the total MBPS seat, and all quota will have to be applied. Even after increasing of the
And that's the what's the reservation policy.
11, 20, 20. Provided by minus 10 with regard to MBPS.
No, it was subsequently adopted in that communication is there. It was. No, it is given the record. No, it is on the record, my friend, that this has been taken into consideration and you have made the document in the motion stage that this has been adopted in the PG. Please don't go back. I can show that document it was adopted in the PG. No, my lord. On day one, my lord, I have seen the video of the motion stage. He has made a categorical submission that this MBBS, this EWS 10% quota is applicable for PG also. And that is why we are all before your lordship. No. I can show you the video, my friend. Your lordship will see the stage of page 100. Your lordship will see in WBC number 6812, madam. Page 100, madam. Page 100, madam.
1 minute.
Your lordship will kindly see page 100 of my petition of 6812. And that document of PG is at page 11 of that compilation, that it is applicable. Page 11 also your lordship will see. Of the compilation of this communications. This subject itself says, my lord. Implementation of reservation of 10% seats in postgraduate. This is a constitutional mandate. You cannot say that you don't have a 10% for PG. That is a constitutional mandate, my lord. You cannot say it is that the constitutional mandate you have to take instruction. That you have to follow. There is communications from the National Medical Council. Now the Board of Governors have said that it is 10%. Now your lordship will see this what has happened so far. The orders of this court are concerned, my lord. Your lordship will first see the compilation. I have given all the orders serially, my lord, at page 14. Now your lordship will see the first order at page 15. 15. Now your lordship will see at paragraph number 8, the chart is given, paragraph number 8, that it is increase in seats needed for implementing of para 8, page 16. This is the chart. And the chart specifically said that increase in seats needed for implementing of EWS quota. And in the next page, your lordship will find 48 plus 3, 51. Then your lordship will see the paragraph number 10 at page 18. Accordingly, the authorities in the medical education department of the government of Assam may continue and complete the admission process of the postgraduate degree and diploma courses in medical sciences for the year 2021 in the medical colleges by increasing the number of seats subject-wise as provided in column 5 of the table provided in paragraph 50 at page so-and-so of the affidavit and so-and-so. So the direction of this court was that you have to increase the seats for the intake of the 10W 10% of EWS category as the table. Then your lordship will see the next order at page 30. 30, my lord. Every year they have to come. 30 it starts. 32 is the same chart, my lord. And the operative portion of the order is at page para 8, page 34. The authorities in the Health and Family Welfare Department may act accordingly and increase the seats as indicated above. The requirement of increasing the seats is to be done so that no inconvenience would be caused to the candidates. It was not so. The exercise was done and distributed among all categories. Next, your lordship will see page 42, para 11. Page 42, your lordship will see the order. Lease the matter again on 17 July 22, by which date the respondents will file their responses positively. Meanwhile, the state is permitted to increase 51 numbers of seats as indicated above. What indicated above? As per the table, that 10% which has to be go to the EWS quota, that 25% increase. In Assam, it is 51. Then your lordship will see the order at page 48. Para 6. Para 6, this is where it is creating the problem, my lord. In the meantime, the authorities in the Director Medical Assam is permitted to increase 51 number of seats for the unreserved categories. Your lordship has added the word unreserved category. That's why this whole percentage has been disturbed. And that's why the chart which I was showing at your lordship will just once more go to the chart at page 3. Page 3. Now, if this 51 seats is given exclusively to the unreserved categories, my lord, then not given to any of these persons at the second last column, then this percentage will go down. And this excess seats of 51 ought to have taken count in the first round itself. If in the first round, it would have taken this 51 seats, instead of total 288 seats, it would have been 339. And out of 339, EWS 10% will be 35 seats, where they have been given only 29 seats, 6 seats less. Every category has contributed to the EWS. Yes, the unreserved category has contributed the maximum number of seats for that category. It may be 21 or 22, because some are fractional, we have rounded up. In earlier occasion, therefore, this honorable court has left it to the discretion of the Director of Medical Examination, DME, to do the exercise. I have just compiled and given an idea to show that this 51 seat is not to be given only to the unreserved category. They are at most entitled maybe 21 or 22, because sometimes when it is 5.4, the director says that 10.5.4, then he may say 10. And in some occasion, he says that department has a less number of faculty. Even if it is 10.54, I will give 10 seats. If he says that if there are more faculty, he may do it 11. That discretion is always there because it is 51 seats. This fraction will always be there because it's an odd number. So your lordship will direct to do this exercise again of allotting this 51 seats. Your lordship will look at page 100, the schedule of my writ petition of 6812.
Yes.
Now your lordship will see page number 100 and a chat 10, column 3. Now your lordship will see the row 3 in the page 3. Unlike locking of choice, this locking of choice will be expiring today at 4 p.m. of 2. Once it is locked, then it is finished. It can't be unlocked because all system generated online filling. So your lordship has to ask them to take this 51 seats into consideration and do the exercise as it was done in earlier. And the 21 seats which the general category I submit, they should also get back. It may be 21 or 22 with mathematical precision to that fraction of a second. That discretion has to be given to the DME. So far the judgment is concerned, my learned friend has read, senior friend has read some of the paragraphs of the judgment. Because there was on the last occasion it was made that if from nowhere in the judgment I don't find any line which says that to uphold the constitutional mandate of 15(6) and 16(6) you have to create additional seats. These are only administrative exercise because of the undertaking given before the Honorable Court during the course of the hearing. That see 10% EWS quota we are giving it, but will not allow the other categories to submit. Will increase the intake capacity by 24% and give it to EWS, which belongs exclusively to the unreserved category. So how I am this judgment, I'm not trying to take any advantage of the judgment, or by taking help of the judgment, my petition can be dismissed in limine without hearing me, my lord. I'm not saying that. I'm not here to argue on the constitutional validity when the Honorable Supreme Court has said that uphold the constitutional validity of 15(6) and 16(6). Second, I am not claiming seats of the 10% EWS, whereas I am saying that because of this unreserved word added in your lordship's order, the EWS category also, who ought to have been given 34 seats, have been given only 29 seats. So because of this non-inclusion, and I don't understand why every time the students have to come to include this 51 seats. They should not have come. They have these people have better work to do. Probably they should concentrate in the job where they are working. So this should put an end, and they should do the exercise immediately so that this is not delayed. So far the suppression and all facts is done, my lord. What has happened? Allotment of seats are done. Normally we filled up the online show. If we in the first round we did not take, so it has lapsed. So we are not taken it. In the second round, because of this addition of 51 seats, we may have better options. So we have forgone the first round thing, and that's why now if this is 51 seats come, the option will increase. But already prejudice has caused to some student. But since they are not before your lordship, the person who is sleeping over his rights, your lordship is not concerned. Because what has happened, if it was 333 seats instead of 228, some persons who have scored better marks in the first round of counseling, they may have better seats. But they have not come, they have not before your lordship. So your lordship need not bother. But people at least who are before your lordship and who says that this has to be proportionately distributed, that rights at this interim stage, your lordship will take into consideration. I don't want to delay the entire process because this is an admission process, time-bound schedule. But prima facie, it appears that the reservation category will go down from 22% to 27%, including all the categories. That's my humble submission so far the facts are concerned. On the law, my lord, your lordship is already aware. EWS judgment is around more than 300 pages. And if you look into the dissenting views of the Honorable Justice, Chief Justice Dan UU Lalit and Mr. Ravindra Bhatt, they have also analyzed. They have said that this 50% Lakshman Rekha, you should not have allowed to exceed. But the majority judgment, Justice Paridwala, Maheshwari, and Bila and Trivedi, the three judges with majority view was that, see, since the constitution has been amended and this 50% is the judge-made law, nowhere in the constitution it says that only 50% has to be given reservation. So this is to eliminate the economic, to take up the, to eliminate the hardship which is facing by the economy. We are going to increase it by 10%. That's why to this 10%, the scheduled caste and scheduled tribe people, they said, no, we also have economically weaker section. We want to get entry into this vertical column. Supreme Court said, no, you are already, your discriminated quotas have been given to you. So you will not ask for it. And that is where the matter. I'm not asking from the EWS quota. I am saying that in the first round, the seats that have been taken and given to the economically weaker section should return to us. And similarly, in case of this unreserved category, there are 21 seats or 22 seats. This competition, the director of medical, they should be given. Why they should suffer? Already they have suffered. But that doesn't mean today they may have the general students, because this is a case, my lord, which is having far-reaching consequences so far the state of Assam is concerned and all over India. Means everyone is watching probably live stream. My lord, so far now, if this, my lord, so far unreserved category or the merit categories are concerned, my lord, if this 27%, 15% to 27% is OBC, which was done from last year, their seats have gone down. But we can't help it when the Supreme Court has upheld the constitutional validity of that order. Economically weaker section, we can't say that that it is constitutionally unvalid because the apex court has said that it is constitutionally valid. So only in the last occasion we missed the assistance of Buddha Gogoi, my friend, who has said that yes, this exercise ought to have been given, because this is what is, we are here to only to assist, and this is pure mathematics.
Yes, Google.
Yes.
Come again. Come in.
I'd like to place two more documents, my lord, which is already part of the record. Of WPC, my lord, 6640. Thus, I'm pointing out, my lord, I'm not submitting that this is the one that should be followed. Page 26, my lord, WPC 6640 of 24. This is the part of the writ petition. Annexure 2 is regarding implementation of reservation of 10% seats for economically weaker section candidates by enhancing of postgraduate seats, PG seats, my lord, in the existing medical colleges and so and so. Lordship, may I read the first para? Further to this office circular dated 12/4/2019 with regard to implementation of reservation of EWS for admission to PG courses in government medical colleges under the control of the state government, I am to request you to send your proposal under EWS scheme in consultation with DMEs under section 10A of the IMC Act 1956 for the academic year 2020-21, not later than so and so. The next line is important, my lord. In this proposal, the increase of 10% EWS quota should be on the seats that stand recognized on the day of submission of the proposal. So, my lord, it means total seats. Whatever was there on the day when the proposal is submitted, 10% increase of seats is to be made. Nobody says that, my lord, that particular 10% will be of the, my lord.
So the increase of 51 seats, which has been given to you now,
yes,
that has to be distributed equally.
That was followed, my lord, in the earlier years also, my lord. And my lord, in the next page, page 27, there is a guideline given by the Board of Governors, 4/6/2019. My lord, here last third para says, in this regard, please find enclosed here in a guidance note about process to be followed along with the so and so. Though it speaks about MBBS, thus I want to point out, my lord, if something can be gathered from this. The third para says, my lord, in this regard, please find enclosed here with a guidance note about process to be followed along with the prescribed pro forma as the next for submission of application to MCI at the earliest. So, lordship will see the guidelines in the next page. The third para. In order to implement the 10% EWS reservation quota, the increase in seats has to be effectively 25% of the current intake.
That is.
So, my lord, para 4 says the calculation of fees has to be made taking into consideration total intake of the students. So, this is for MBBS, but I don't think so, my lord. There will be a separate, my lord, guidance for, my lord, guideline for PG and, my lord, separate for MBBS. After all, my lord, 10% increase is to be made on the total seats. As per this, my lord, communication at page 26. Seats in the respective subjects. In post-graduation, my lord, the admissions are given according to the subjects, preferred subjects by the student. So rest I leave it to your lordships, my lord. These are the documents, my lord, which are holding the field, and both sides has annexed this, my lord, in their respective petitions as well as the interlocutory application that has been filed today.
What is page 31? The third last para.
But this was a speaking order, my lord. Whereas in the current academic session 2020, after the All India second round of counseling for at that point of time, there were certain vacancies. Considering, my lord, that situation, this order was passed. And this was passed pursuant to the order of the Honorable Court, page, my lord, lordship will see page 30, first para. Judgment oral dated 25/20 was passed by the Honorable Court on so and so on 22/22/03 of 2020. Considering that order, my lord, this order was passed.
Okay.
My lord, DMA's understanding of law is not, will not guide your lordships. Lordships will go by the Supreme Court and the.
My lord, we will go by the order passed by the honorable
Yes,
court. We
yes,
have not
yes.
preferred any appeal against the last order, my lord, of the interim that was given, my lord.
Let us not go by the DMA's understanding of what is 10% EWS.
What you are trying to
Now let us understand what is the petitioner's case. My lord, the earlier orders left 2 months of leg room for the DME. This time there is caught. Now that's why my learned friend is also having problem now. Please come to page 7 of the second petition filed by my learned friend. Let us understand, my lord, what is his case. I'll go to his arithmetic and mathematics. Para 5, para 3, page 7. This is his case, my lord. That the petitioners are aggrieved by the decision of the respondents to exclusively allocate all the 51 increased postgraduate medical seats for the academic session 2024 to unreserved category alone. So it's very unequivocal, my lord. He says that is his grievance. Now, what is wrong in this seat, my lord? If the authority has done it, what is wrong in it? These seats are increased for whom? Let us be logical. Let us not beat around the bush. Kindly take this compilation he has given me, Lord. The very first page. In the earlier orders of this honorable court, my lord, the word unreserved was not there. That was being taken advantage of by reducing the seats meant for EWS. Now, please come to this first page, my lord. Page 1. This is the part of the affidavit filed by the National Medical Commission in the first writ petition, when Honorable Justice Bujor Borough, my lord, took note of it. Now, kindly see, 39 seat was for medicine India in 1920. Now, reservation was 37%. So it works out to 14.48. Let us 15. So after, if we deduct 15 from 39, my lord, open merit seats unreserved quota remains is 24. Now, my lord, to implement the 10% quota, as so far as medicine is concerned, 6 seats are required. So, having regard to the requirement in different subjects, my lord, they have worked out. As far as postgraduation is concerned, it works out to 48. And as far as diploma is concerned, it works out to 3, therefore 51. Now,
I'll just correct a mathematical correction. 39, first row 39, 37% will be 15 seats, open merit 24. If you calculate 10%, it will be 10 seats, but it was given 6 seats.
Anyway, you have done your part. Let me explain my part. Yes. No, I'm going by this. I'm not saying anything else. I'm going by the affidavit of the NMC, which was taken note of by this honorable court for passing the order for the academic session 2021. It's not my argument. Now, according to NMC, my lord, to implement 10% quota, one medicine, what was required was 6 number of seats. Now, if we accept my learned friend Mr. Kumar's argument, my lord, what will happen? Now, please come to this first column again, 39. Now, this 6 has to be added here. Now, work out the my lord percentage, then what happens? That is what intended by the 103rd Amendment. Why are they confusing? My lord, earlier years, the medical director, medical education misconstrued the whole thing. It was never meant to be distributed amongst all. It was meant to be only for the economically weaker section.
But come to page 3 of the same,
Yes.
that same booklet.
Yes, yes, yes. Yes, my lord.
Yes. Here he has made a chart.
Yes. But this is not subject-wise. It has to be made subject-wise. Where is the subject-wise calculation? My lord, the NMC's thing was very clear. It was subject-wise. My lord, that's why I said, what is their locus? What the seats? My lord, what will happen? Now this increased seat will go to everybody. Whosoever's annual income is less than 8 lakhs, everybody will get it. So that word unreserved has to be there. And now they have understood it. Earlier, they were given in scope not to understand it. This time, your lordship's order is very unequivocal. Therefore, it has hit the eye. Bullseye. Now, what is wrong in it? Now, if we accept my learned friend's argument that this position will emerge, my lord, 3 is the only, my lord, sum total of his, my lord, submissions. We'll file our affidavit in their case. We'll come out with everything, my lord. It's not correct. My lord, please come to the judgment for a moment once. One paragraph. After this, where is the scope? I think I'll have to place this para 150, my lord. No, 150. Please come to me, Lord. The argument was, please come to para 147 for a moment. Relying on Indros only, my Lord, this argument at page 163. Please come to para 147. The fact that exclusion is innate in compensatory discrimination could further be exemplified by the fact that in Indros only, this code excluded criminal layer of OBC from the benefit of reservation. In the complex setup of formal equality on one hand and the real and substantive equality on the other, which permits compensatory discrimination so as to upset the disadvantages, exclusion is indispensable as the compensatory discrimination itself is. Now please come to para 150. After referring to other authorities, my lord, at page 164. Having said so, even if it be assumed for the sake of argument that amendment in question alters the existing equality principle, it is not an abrogation or annulment of the existing rights, but could only be treated to be one of moderate abridgment thereof for a valid purpose. There could be some, my lord, here and there could be some upset, but that will not, alter the basis of the action. Thus viewed, it cannot be said that the amendment in question leads to such a violation of the rule of equality, which is shocking or is unscrupulous travesty of quintessence of essential of equal justice. Well, this argument which my learned friend is making today was also made before the Supreme Court. And Supreme Court has answered in para 150. Now, my lord, end of the day, if it is to be added to the whole seat, now, my lord, will come down to the same fact, same figure. Then again, we'll have to work it out. I can also come up with a chart like which my learned friend has done. Well, end of the day, the purpose has to be seen. What is the object of this amendment? Object of the amendment is to earmark some seats for economically weaker section of the society. Yes, the argument was advanced that if you go by the Constituent Assembly debates, what would appear is that this reservation is meant for socially and educationally backward class. This economic criteria was never taken note of in the Constituent Assembly debates when this provision for reservation was inserted in the Constitution. The Supreme Court says no. That is also compensatory. End of the day, my lord, these are all affirmative action in terms of Article 16.4. Otherwise, the equality which is ensured by Article 61, it can be tinkered with under Article 16.4. So, my lord, what is the wrong in it? And why at this stage, my lord, lordship will, if your lordship is inclined to hear them, though I have said that they do not have locus, lordship will hear the matter in an appropriate date. But there is no question of altering the interim order, my lord. And assuming tomorrow, if lordship the situation comes, where lordship finds that no view is to be done, your lordship's hands are not tight, my lord. Your lordships can undo things. This unlocking, locking is not going to, cause any problem for anybody. And my lord, out of 83, 32 seats are also there. These are still remaining. Now, my lord, end of the day, if lordship accepts the contention of my learned friend, Mr. Bhaswardev Kaur, my lord, in that case, lordship will be recognizing the right of persons who are beneficiary under Article 15.4 and 15.5 to also EWS. Is that the intendment of the amendment? That's why I have referred to para 3 of the writ petition, very clearly says that a wrong has been done by not including other than unreserved in this 51. Well, it defies all logic. It defies logic. I can also come up with a chart. That is, let them come up with a subject-wise chart. When NMC made the calculation, they made subject-wise. If now they are to show that there's something wrong in that, they'll have to show subject-wise. And my lord, kindly see, the director of medical education, maybe my lord, I don't say it is an, deliberate act. Every time, my lord, the letters which is writing to the authority, even the letter which is written on last of November, well, is it conceivable, my lord? Is it so unintelligible, your lordship's order, that every time he is writing a few absurd things and NMC has to come every time to their rescue, my lord? Now, it's a question of implementing EWS quota. Where does a person who is a beneficiary under 15.4 and 15.5 figure? That's the fundamental question. Therefore, my humble submission is, my lord, forget of anything else, my lord. He doesn't even locus standi, even to poke his nose in these matters, my lord. He is nobody to question this. Supreme Court says it's not me. I'm reading that passage once again, my lord. Page 1, para 144. Putting it in other words, the classes were already recipient and beneficiary of compensatory discrimination by virtue of Article 15.4 and 5 and 16.4 cannot justifiably raise the grievance that in another set of compensatory discrimination for another class, they have been excluded. Well, this is the question which Supreme Court has already answered. Now, if your lordship wants to take a view, as is sought to be argued, my learned friend, then your lordship will go against para 144. That is in nutshell my submission. It clearly says, my lord, I'm reading it once again, cannot justifiably raise the grievance that in another set of compensatory discrimination for another class, they have been excluded. It gets perforce reiterated that compensatory discrimination by its very nature would be structured as exclusionary in order to achieve its object. Rather, if the class for whom affirmative action is already in place are not excluded, the present exercise itself would be unjustified discrimination. So I don't think, my lord, there is any scope.
Reply to the judgment, because my learned friend has placed new facts in the.
I have not placed any new facts. You have already made your argument.
Just let me place 2 lines on the judgment. Let us make myself clear that I'm not against the 10% allotment of EWS, which has been constitutionally held to be valid, number 1. Secondly, when the Constitution Court says that as a SC, STP or reserve category, I'm not entitled to get into the 10% quota. Let us be very clear, these 51 seats which are for the economically weaker section should go to the economically weaker section. That's my plea. But what the DME has done in the first round, they have not added this 51 seats to the total seats. As a result, this economically weaker section has taken seats from us as well as 21 seats from them. So I want that this total sheet, instead of asking them to do the exercise once again from the first round of counseling, I'm asking your lordship that whatever seats, the 21 seats which have been taken away from the meritorious candidates should go to them. And similarly, the seats which were taken from us and given it to the EWS category should be restored to us. But if you give these 51 seats exclusively to the unreserved category, then the reservation of 27%, 10%, 7.5% will be reduced. And they are not saying that this 51 seats should go to the economically weaker. Unreserved category has 2 categories, just like OBCs, creamier and creamier. I'm not trying to undo any judgment or any ratio laid down by the Honorable Supreme Court. The paragraphs, if your lordship looks into why this case was filed, at paragraph 2 only it says that there are 5 issues, 3 are main issues, 2 are incidental issues. The Supreme Court has the paragraph which, if you take a single paragraph, it is difficult to understand. Okay. The Supreme Court has said that we cannot ask for this compensatory reservation because we are already a benefit of reservation. So if on today, if your lordship distributes this entire 51 seats to the unreserved category, it will have a far-reaching cascading effect, not only for the state, the entire quota of reservation, my lord, all over India.
Okay. What's your IA?
My lord, 1 second, 1 minute, my lord. Now, I have already read para 3 of their writ petition, that is their case. Lordship will kindly have due regard to that. And secondly, my lord, my learned friend has not answered that they have already in the first counseling, they have all got these seats. Why that averment is not there?
No,
My
we
lord,
have not
Lordship will
taken it.
kindly, upon instruction, I am making this submission, my lord. They have got admission in the first counseling.
No, there's a lot of difference between allotment and admission. I may give a choice, but I may not take the choice.
You have got it.
No,
You
no,
have
no,
got
no,
it.
no.
And secondly, you should have said in your writ petition
I am not.
that in the first counseling, I have got this and that.
I am not referring to the pleadings made in the.
Whether you accept or not, that is
pleadings
your
of the-
case.
Pleadings of my learned senior friend. If I go through the pleadings of my learned friend petition, none of these averments are there. They are trying to.
And we are not
Well,
even party.
we are magnanimous enough to make you party and address us, address the court.
Thank you very much.
Okay, you want implement.
Implement and modification of the order also. But in the main petition, in our petition, we are seeking for an interim stay.
My lord, in the imprisonment, I have a right to object.
Yes,
Yes,
yes, yes.
I'll object.
Yes,
I am objecting their imprisonment.
You are objecting the.
Yes,
Yes,
100%. And
And
file
so
affidavit
far,
also.
our case is concerned, it is consideration from the interim order, that order was well. That's why in our case, because these are all subsequent development after your lordship's order and after this new cause of action has come, that's why we have come with a fresh petition. Because if you had not come with the fresh petition, we would have not been able to address this issue, which are not part of the record. So in our case, we are seeking an interim order.
What interim do you want?
My lord, this counseling process, which they are going, should be stopped till this 51 seats dispute is resolved.
How can I stop the counseling process?
Well, if your lordship if your lordship gives the entire 51 seats to the unreserved category, your lordship will not create disturbance in the
Okay, okay. Heard Mr. B.D. Gonwal and a senior counsel, assisted by Mr. P. Dole for the applicant. That is in IA 3990.
Yes.
Issue notice. Mr. Ken Chowdhury and a senior counsel. Appearing for the.
Writ petitioner.
No.
My lord, there are two writ petitions. I am petitioning item 28.
No. Appearing for the opposite parties.
Writ petitioner.
Assisted by Mr. J. Patori. Appearing for the opposite parties 1, 2, and 3. Praise for a week's time.
A week's time will go take us to the yes. 1 week's time.
Praise for a week's time to file objections. Praise allowed. When do you want?
My lord can have it on 9th, my lord. 7th.
Yes, 7.
9th is fine, 9.
9th is the.
9th, my lord, I think
Yes,
so many
7th
cases has been. Let it be 7th. Or maybe then following week.
Okay, 7th. And in the writ petition?
My lord,
In the writ petition, there is already an order, my lord.
and
No,
they
that's
have
fine.
No, my lord, it's today for consideration of the interim prayer, my lord. I have
No, I'm on his writ petition.
In
They have already
petition,
accepted
there is already an interim order, my lord. This state is working on it.
Okay, then in the writ. You want it on 7th, correct?
Yes.
No, my lord, 7th, I have a sub problem, my lord, on 9th, my lord.
Okay, my lord, if in case I have some difficulty on 9th, my learned friend will accommodate.
9th. And in the other writ petition?
My lord, 6812.
Heard Mr.
B.D. Kormala, assisted by
B.D. Gonwal and its senior counsel assisted by Mr. B. Dole.
P. Dole.
Learned counsel for the petitioners. I'll issue notice.
Yes.
My lord, then your lordship will reject our prayer for stay. At least we can test it in the high court, my lord, then.
Yes.
Because this has to be taken to its logical end, my lord.
Okay. Issue notice. No, don't say like that. Okay, I'll issue notice and list it on 9th.
My lord, my
this one
interim
also.
prayer, your lordship will
That
reject.
interim prayer, I'm rejecting it.
Yes,
I'll pass orders appropriately.
Yes.
At least we can test it, my lord. It's
Yes.
not that but we have all to take it to the logical end.
Deep reply.
This one you keep it with me.
Let it be on 6th, my lord, because Lordship will see, my lord, if something, my lord, order is passed, my lord, against this particular interim order, because we'll have to go ahead with the counseling.
I don't
Let it be
know
on
object.
6th,
6th,
my
I
lord.
have
Let
no
it be 6th,
objection.
my lord.
Yes.
Or on 3rd itself, my lord.
Then
Not third.
6, okay,
6.
6.
No,
6.
And then do I consider the interim today or not?
No, no. Well, let it be on 6 months.
That's what I'm saying. Let it be.
Then I'm not considering the interim today.
Yes, ma'am.
Okay, then,
6
then I'll say issue notice. Issue notice, Mr.
Well, 6 I am out of station.
Final
Mr. B. Gogoi, Standing Council, Health Department.
Well, on 6 and 7 I am out of station.
1 minute, it's okay.
Then 8 kora.
Leonard Standing Council, Health Department, appears for the respondents, 1, 2, and 3. You don't have the repetition. Mr. Baitia. BK Baitia, Leonard Council, Leonard Standing Council, NMC, appears for the respond number 4. And Mr. K.N. Chowdhury, Leonard Senior Council, assisted by J. Bhattori. Their council appears for respondents 5, 6, and 7. Notice and responses are complete. How extra copies? Well, list the matter. When do you want?
8.
8. Then the other one was 8.
8.
Yes.
Other one 8.
Lordship will
This one
indicate
list the matter on 8
or final disposal, madam.
Yes, final disposal.
for consideration of the interim or final disposal of the writ.
Miller. Deep.
And in the meantime, the earlier will interim will remain, madam.
Yes,
So we
yes,
will
yes,
continue.
yes,
No, my lord, then my lord, see, my lord, what will happen if your lordship will be at least reject our interim grant. Because we have argued, my lord. Your lordship is not granting us, your lordship will reject it.
No, then I'll say like this, the distribution of seats.
Yes.
Of the 51 seats.
Hmm.
In terms of the order dated so and so, passed in the first week petition. Shall be subject to the outcome.
Yes.
Okay.
Yes. Then it's fair for at least for that on 7 we can argue.
Yes, what do you want?
With regard to item number 34, we have certain difficulty in the second of lordship. It is challenge a disciplinary proceeding. He needs instruction with that can be fixed after the vacation lordship.
Item
34 of the supplementary list lordship.
Who wants?
That can be fixed after the vacation.
Okay, heard Mr.
D. Dekalo.
Learned council petition on request made by our Madam, when it's standing council. University when?
Let it be after in the second week of January.
Lordship, he may get the instruction
After the winter vacation.
with the instructions.
To enable him to receive instruction.
My lord, we have a leftover item number 12. In that case, my lord, we've just received a copy of the affidavit by examination from 28. Can it be come listed tomorrow with along with the affidavit? Otherwise, there will be holidays from Mondays, my lord, because the examination from 29.
Okay, wait, I'll pass order.
Lordship.
For tomorrow, my lord. You listed in the second bench, not before this court. I can't take up tomorrow. It'll come up tomorrow before the other bench.
Order passed by my lord, yes.
Doesn't matter. Let us see. No, why are you coming so late?
I apologize, my lord.
No. This, have you informed Fokan?
My lord, I have served a copy to my senior from the other.
Yes. Call up.
Item 12.
My lord. Oh, this deeply obliged, my lord.
Yes.
My lord, in this case, my lord, they also first half of the day didn't appear, but I received a copy of the affidavit, my lord. Now, affidavit said, my lord, lordship, may I hand over my lord, a copy of the affidavit, my
When
lord.
was the affidavit filed?
Affidavit filed, they said it is filed today, my lord. We have received a copy at 12 o'clock.
By which respondent? 1, 2, and 3?
1, 2, and 3, lordship.
Where do you ask the council?
Council is, my lord, it's not there.
Mr. Fukan has filed this affidavit.
Yes.
Where is Mr. Fukan?
The urgency is there, my lord, because now para 4 and 5 they said, my lord, if I just hand over, my lord, the lordship so permit.
My lord, you'll see. হ্যাঁ আজকের ওখানে আছে মনে আছে আমি জেরক্স করে বলতে 4 and 5 my lord, what they said in the 4 and 5 lordship will find that second sessional examination that what you also averred in our petition my lord.
Okay, we'll take up tomorrow.
My lord,
You go to counsel for the petitioner. Mr. P.G. Pupan. When did he file it?
It filed my lord according on today my lord 14/12.
That standing counsel Guwahati University submits that he has filed an additional affidavit.
Affidavit to we have received it today now.
There's already an affidavit from him, isn't there?
Yes, yes.
1, 2, and 3. Earlier he had filed.
Earlier he had filed, today also he filed, and we have received another affidavit, additional affidavit he has filed, my lord. 19, on 19/12. The 19/12 copy I have handed over.
Verify and place the same on record. And list the matter on 20.
My lord, is tomorrow?
Yes.
Lord.
Item 22.
I'm sorry, Lordship, I was not here. Lordship, other side was to receive instruction, Lordship. With regard to my, because this court has first order a reinstatement with all consequential benefits, so.
Yes, sir.
I have not paid off.
Supplementary demand has been sent to the government, Lordship. As soon as PTC authority receives a supplementary demand, they will pay the arrears, Lordship. Kindly see page 30, Lordship, in the.
No, what is there in this? After you receive the supplementary demand.
Payment shall be made after receiving supplementary demand.
How long will it take?
That's the.
Let the matter come after due vacation. Let us see what development.
In the meantime, Lordship, issue notice, Lordship.
It's a P. Chagapatil and the counsel for the petition. There's no point of issuing a notice in this. This is a small matter. MSS Bora, London Standing Council, RB Bora, London Standing Council BTC submits that the who sent the supplementary demand?
Lordship, kindly see page 30 of the petition, Lordship. Secretary BTC requested the director.
Okay, I'll request made by SR Bora, RB Bora, list the matter after the verification to enable her to receive instructions.
29.
The petitioner is a science graduate. He passed the 2 years DLED course conducted by the SCRT Assam. Thereafter, he passed the central TET as well as the state TET. On the basis of his performance, he was appointed as assistant teacher. Lordship will find it page 31. His appointment order. He was posted against a sanctioned vacant post. Annex 9. Subject to discharge without notice, without assigning any reason thereof, Sri Vishal Kar, BSc B DLED TET is hereby appointed as assistant teacher science graduate at Kolyan Bengali AMI School, Dhansiri, Karbi Anglong against the vacant post. And this order is made pursuant to the order of the Deputy Secretary, Department of Personnel, Karbi Anglong.
Then what happened?
He was serving, he was getting the salaries, thereafter, but for the regularization of the salary, the investigation of the documents was conducted by the CAC. Now I am informed that the certificate issued by this SCRT at page 25, my lord.
Page?
25, my lord. There is an inadvertent mistake on the subject study center code, my lord. Otherwise, that my name is correct, registration number of SCRT is correct. That the lordship will find it third line study center code. This 221, my lord. It is not tallied with other documents, my lord. On the pretext of it, my lord, my salary is held up now, my lord. And I have requested the SCRT and the basic training center, Karbi Anglong, my lord. They are not taking any steps to rectify it. At the same time, my salary is not really.
Since when your salary was returned?
My lord, initially I was paid salary up to March 2023. Then, since there is no approval of the finance department, all the incumbents' name are forwarded to the finance department. Now, from the month of October 2024, my lord, other incumbents I have annexed at page 33, annex 11, my lord. They have been granted salary, my lord, from the month of October 2024. My lord.
October.
October, my lord.
Except you.
Yes, except me, my lord.
Yes.
No, my prayer, my lord, at this stage, notice may go, my lord. In the meantime, my lord, I may be allowed.
I'm not for the SCRT, I'm not for that. That's problem.
SCRT, Chaudhary, is that?
I am very, but it was never stop.
My lord, the name has been shown in the. Yes, I'll serve the copy during the course of the. I'll serve the copy. Yes.
Okay, heard, Mr.
P. Hazarika.
Then the counsel for the petitioner, we should notice.
Copy din under that.
Elementary.
Oh, one.
Mr. SMT Chishti, Learner Standing Council Elementary Education, appears for respond number 1. MS Finance.
Finance, I have also made.
RM Barwal, Learner Standing Council Finance, appears for the respond number 2. Karbi Anglong, you are appearing. MS K. Kempre, S. Kempre, Learner Standing Council KHD,
4 and 7.
appears for 3, 4,
7.
and 7. SCRT, Mr. G.
5 and 6,
Learner Standing Council, SCRT appears for the respondents. 5 and 6.
5 and 6. 8 and 9, I'll take steps by registered code.
Extra copies of the petition. Respondents, petitioner to take steps for service of notice on the respondents 8 and 9 by registered post 80 within 1 week from today.
My lord, may I pray, my lord, my current salary that may be released, my lord.
Release the matter after 4 weeks. Okay. We'll consider on the next written.
My lord, that may be observed, my lord.
The respondents are also directed to the Learned Standing Council for the respondents are also directed to take instructions as to why the current salary of the petitioner has with regard to the payment of current salary to the petitioner.
My lord, I'm obliged.
30.
My lord, petitioner is presently serving as an IC principal of Lokinath Besbora Higher Secondary School of Basta district. He is on the verge of retirement. He is now more than 58 years old. During his service career, no stigma has been attached to him. On page 20, one so-called notice has been issued to me.
Okay.
On the Ellis ground that one teacher of my school, one colleague has retired on 31st March 2023, and there was some delay of releasing his GPF account. My lord, before issuing this so-called notice, when I came to know that the accountant general has sent the necessary papers, advice slip to my office, but it was somehow misplaced. And when I came to know, immediately I requested the authority, page 24, before issuance of the so-called notice. Page 24. On 28/8/2024, for reissuance of the advice slip. But I have admitted that there was some miscommunication. The peon who has received the advice slip that was not brought to my notice. And after that, my lord, page 25.
When was this written?
That man has retired on
No,
21st.
no, when was this letter written?
Letter, my lord, that date is there 28/8/2024.
Page 24?
Yes, my lord.
Where is that?
Subject, below subject.
Okay, okay.
Yes. Before issuance of the so cause notice. My lord, on my initiative, my lord, page 25. The complainant, who was my colleague,
Mm.
has received all the amount with interest in his bank account, my lord.
The GPF amount?
Yes, my lord, all has been received. 25, 26. This is payment slip. Page, then page 30, all everything he has received.
Okay.
In spite of that, my lord, I have also communicated that the complainant has already received all the amount. Page 31. On 13/11/2024, there is no grievance at all. In spite of that, my lord, page 32. Since the complainant has received all the amounts, there is no grievance. I have been placed under suspension, my lord, page 32. On the same cause of action, which has already been settled by at my initiative, my lord. After retirement of my colleague, I have helped him in submitting all the proposal. I have written the number of documents to the authorities, but since there was some communication gap or the advice slip was not brought to my notice, and even my lord, that complainer also never approached me earlier. Instead of he went to the authority for filing complaint. On the basis of complaint, I have been placed under suspension. My lord, since that complaint has already got the relief, there is no necessity to keep me out of service, my lord. There is a number of
When are you retired?
my lord, in the year 2026.
Okay.
There is no, I have rendering unblemished service in my service career, my lord. Though suspension is not a punishment, but it.
Yes, Nayak.
So I have paid for stay or
No.
revocation of my.
The suspension is already in effect.
Yes. And I have filed the appeal, my lord, that may be disposed of, my lord, within a time frame.
Lordship, may kindly come to page 20, Lord.
Yeah.
Page 20. This is a report given by the inspector of school. This is in fact the so cause. Lordship comes to second paragraph. As per petitioner, it is to be mentioned clearly that it has been verified by the nearest post office that the parcel of GPF order copy has been received on 2nd August 2023 by Ashwini Das, in charge principal of the school. But he is not enabled to receive the GPF amount order copy till date from your end. As a result, he compels to apply for same procedure to reissue the new copy. Lordship, it was received on 2nd of August 2023 by the principal himself, as has been confirmed by the concerned post office. And that is why sir's level against him is negligence of duty, negligence in duty. And Lordship just now heard he is harping on the point that I am going to retire. Lordship, because of his fault, Lordship, one retired person was unable to receive his GPF amount from 2nd of August 2023 till September 2024, Lord. That is one, Lord. Secondly, Lordship, this suspension was only on 4th of this month. And he filed one appeal on 6th of this month. And this petition was filed on 16 after 10 days, Lord. We hardly got 10 days time to dispose of his appeal, Lord. I don't see any reason why your Lordship will interpret at this stage, Lordship. Lordship will issue notice, or Lordship may dispose of this petition, directing the authority to dispose of the appeal, Lord.
Within time frame.
Okay. Heard Mr. N. Sham, let us also put a petition. Also heard school education, who happens? SMT Chishti, Leonard Standing Council, Secretary.
Yeah.
Secretary for the Secondary Education Department for the respond number 1. Mr. P. Nayak, Leonard Standing Council, BTC, for the respondents 2 and 3.
Respond number 2, 3, 4, Lordship.
2, 3, and 4. And Treasury Officer?
Treasury Officer, Lordship, kindly record A. Celia's name.
Mr. H. Alia, Leonard Council, okay, Miss Arambora, Leonard Standing Council. Finance Department for the respondent number 5. Stop. The petitioner is aggrieved with the order dated 4th December 2024, issued by the Director of Education, Botolan Territorial Council, by which the petitioner has been placed under suspension with immediate effect due to his serious negligence of duty, causing delay of withdrawal of final GPF amount of a retired teacher. Stop. It is the case of the petitioner that while he was serving as in charge principal of Ellen Basbura, correct?
Yes.
Higher secondary school. What is this? Butipua Pari.
Putipua Bar.
Who was the government servant who retired?
In fact, he was the complainant. He is the complainant.
On 31st March 2023. Page 20. Vipul Chandranath.
Page 20. First paragraph.
Who's the complainant?
Yes.
Yes, the complainant. Vipul Chandranath.
Page 26.
One Shri Bipul Chandranath, who had retired as an assistant teacher of Ellen Besborough Higher Secondary School, Budi Buapari, lodged a complaint inasmuch as he was not being paid. He was not being paid the final GPF amount after his retirement on 31st March 2023. Stop. Accordingly, the Inspector of Schools, BTC Mushalpur, wrote a letter to the petitioner. In the meantime, the petitioner took all necessary steps for paying the final GPF account amount to the retired teacher. Stop. The petitioner also wrote a letter on 28/8/2024 before the Accountant General within bracket A&E Assam with regard to the misplacing of the GPF. What was misplaced?
GPF payment order.
The GPF payment order in respect of the retired teacher, and requested to reissue another GPF final payment order. Stop. Thereafter, the retired teacher received all his GPF amount on 19th of September.
It was sanctioned and he received on
2024.
page 30.
This was sanctioned on 19th September 2024, which was received on
39/2020.
2024. On 2024. Is it 39 or 29/9? On 29/9.
Page 27.
Stop. However, the Inspector of Schools, BTC Mushalpur, issued a show cause notice to the petitioner on 2nd September 2024 with regard to the delay, with regard to the inasmuch as the said Shri Bipul Chandranath was unable to receive the GPF final payment order. Stop. Thereafter, the Director of Education, BDC, issued the impugned order dated 4th December 2024, suspending the petitioner from service. Stop. It is the case of the petitioner that he is retiring in the year 2026, and that the misplacing of the final final payment order with regard to the said Shri Bipul Chandranath was due to some inadvertent mistake on the part of the petitioner and was not deliberate. Stop. Further, as the said Shri Chandra Bipulnath had received his GPF amount in full, there was no necessity on the part of the respondents to suspend the petitioner by the order dated 4th December 2024. Stop. The further case of the petitioner is that he has he has filed an appeal before the Director of Director of Education, BTC Kokrachar,
With a copy secretary.
on
6/12.
6/12/2024, a copy of which was also endorsed to the Secretary, Department of School, BTC Kokrachar. Stop. Para. After hearing parties, learned counsel to the parties, and considering that the appeal filed by the petitioner on 6/12/2024 is still pending before the Director of Education, BTC Kokrachar, respondent number
3, 2 and 3. Director 3.
respondent number 3. This writ petition is disposed of, directing the respondent number 3 to consider and dispose of the appeal filed by the petitioner on 6/12/2024 by a speaking order and in accordance with law within a period of 60 days. Make it 1 month. Within a period of 1 month from the date of receipt of a copy of the order of this court. With the above observations and directions, writ is disposed.
Highly obliged. Obliged.
31.
May I please, your lordship? My lord, in this case, my lord, the petitioner are before your lordship with a very limited prayer, my lord, for allowing them to submit a representation before the secretary to the Department of Elementary Education, my lord. My lord, similarly situated case has already been disposed of, my lord.
Do you need a direction from this court to file a representation? You can straight away file a
Yes, my lord, the present petitioner tried to submit a representation, my lord, but it was rejected. Wherein, my lord, the government stated that the only petitioners who were part in the earlier litigation, my lord, their cases will only be considered, my lord. In that regard, my lord, a direction may be passed, allowing them to submit representation, my lord.
My lord, generally, randomized in these kind of they will represent. They will receive, my lord, the representation. I don't know why he's saying that.
What is your case?
My lord, the petitioners were initially appointed in the year 1993 to 94, my lord. But they were regularized after the implementation of the new pension scheme, my lord. In that regard, my lord, they were brought under the preview of the new defined pension scheme, my lord. The only contention, my lord, they have already rendered their service prior to implementation of the new pension scheme, my lord. In that regard, my lord, their cases might be considered for being brought under the preview of the old.
Fukan, I think there are some similar matters pending before this court.
My lord.
With regard to the old pension scheme and the new pension scheme. And practically, and also taking into consideration the government has given a undertaking that for those whose recruitment process started before a particular date,
My lord.
they will come under the old pension scheme.
My lord.
Correct.
My lord. 1 to 2005.
Then we'll issue notice here. We'll consider.
Issue notice.
Heard, Mr.
PH Corman.
PH?
PH Corman.
Cornwall and the counsel to the petitioner. Issue notice. Mr. A. Fukan, and the standing counsel, elementary education, appears on behalf of the respondents.
All the response. Except for number
Who is respondent number 3?
3, I'm appealing for 3, man. Director.
Is it director or
In the petition, it's director.
respondent number 2?
My lord, two is director. 3 is my lord, it's a typographical error. It should be district elementary education officer. It's given
District
direct-
elementary education officer.
Made a mistake.
1, 2, and 3. And finance?
Oh, my lord,
MS.
HLE has name maybe record.
RM Borough, London Standing Council, Finance Department appears for the respondent number 4. Notice and respondents incomplete. Respondents extra copies. Respond allowed to find out list of the folks.
Obligation.
32.
May I please Lordship? Here the petitioner Lordship, after completing the MSc Mathematics from Tezpur University and B.Ed from Assam University, in the year 2009, on the basis of interview, he get an appointment as an assistant teacher of the Common Junior Basic School. After Lordship, he was transferred from one school to another school. On 8/5/2023, one guardian of the student Lordship filed a complaint before the respondent number 2 that petitioner has assaulted his son on a triple matter Lordship. Therefore, the said complaint was transferred, respondent number 2 transferred to the sent to the local police station Lordship. On the next day Lordship, when the petitioner went to the school for discharging his regular duties, so from the classroom Lordship, the petitioner was arrested by the police Lordship. So therefore Lordship, petitioner was released by the London Judicial Session Judge Lordship. And on the basis of said arrest Lordship, he was Lordship suspended by the responding authorities on 11 May 2023 Lordship. And the Lordship, page 26 Lordship. And
Yes.
page 26 Lordship, the suspension order of the petitioner Lordship. So, Lordship, may I read Lordship?
Are you still under suspension?
Yeah, still I am on suspension Lordship. Already so-called notice was issued and I have also submitted the reply and hearing is also completed Lordship.
Where is the show cause?
So-called notice Lordship, page 27 Lordship, during page 27. And accept full Lordship.
All right.
Yes, sir.
You submitted the written
Yes,
statement?
yes, I have submitted my reply on page 29 Lordship.
Okay.
Page 29. Thereafter Lordship, hearing was completed, date of hearing was fixed on 29 November 2023 Lordship. I was attended and gave my reply Lordship there also. But petitioner also submitted his representation for his reinstate of the post Lordship. But till now Lordship, the respondent did not reinstate him Lordship.
Was it reviewed? Your suspension order was reviewed at any point of time?
Still not, they have not reviewed Lordship, neither review.
Yes, Chityan.
I may allow some time to take instruction, whether it is reviewed or not by.
Third, Mr.
NH Lordship.
NH last call on the counsel for the petitioner. MSS Chutial and a standing counsel. Elementary education shall take instructions as to whether the suspension order
Is reviewed on.
dated 21st August 2023.
No, sir. Lordship,
No.
2023.
Dated 11th May 2023. Issued by the Director Elementary Education Assam has been reviewed at any point of time. When?
After vacation.
After vacation, I did it.
After the window vacation.
Maybe on
At least after
8
2 weeks.
Not
No,
8
no,
mile,
Lordship, maybe given date Lordship, kindly Lordship.
12
8
mile.
12 was vacation.
It will come up. It will come up.
20. After vacation Lordship.
Yes.
I live.
Item 35.
Lordship, here is some one typical error Lordship. In the year Lordship 2023, it should be 2023. But due to typing, it's 2024 Lordship. So I may be allowed, sir, 24 was corrected Lordship.
Have you seen that notification of the High Court?
Okay, yes, Lordship, I will give it some.
This case is there or not? This page is there. Okay, what is it? This is. Huh? Okay, okay.
May I please, Your Lordship? My lord, this writ petition is preferred against the order of transfer of the petitioner by the district commissioner, who doesn't have any jurisdiction to do so, my lord.
Okay.
That is at page, my lord, improving order is page 22. May I read that, my lord? In pursuance of the mission director's Samagra Shiksha order by number so and so, for smooth functioning of civil works activities and other associated works under Samagra Shiksha Karimganj on 1 JU 1 block basis, the following engineers are hereby entrusted to look after all the matters related to civil works under different education blocks. Earlier, the petitioner was doing in Ramkrishna Nagar block, my lord. But he was now entrusted to North Karimganj. That is at CL number 4, my lord. And respondent number 7 is at CL number 2. He was given my block. Now, if lordship kindly come to page 21.
Yes.
This is the order, my lord. In pursuance of the resolution of the 15th Executive Committee meeting held on 4th May 2024 and subsequent approval from the Government of Assam Department of School Education, the Mission Director Samagra Shiksha Assam is engaging controlling authority and disciplinary authority for the following district and block level post. 1, 2. 2 is the junior engineer. The petitioner is the junior engineer. So, entire power is given to the mission director, not to the district commissioner. But in the impugned order passed by the district commissioner, my lord. And at page 20, my lord.
Yes.
Earlier occasion. In pursuance of partial modification of earlier order so and so for smooth implementation, monitor and function of all civil works activities and other associated works under Samagra Shiksha Karimganj, and as the number of school is very high in RK Nagar and Patharkandi education block, the following engineers are hereby additionally entrusted to look after all the matters related to civil works to the under mentioned development blocks. Now, one number. This is the respondent number 7 here.
Okay.
He was given Dulapsera development block, which comes under the block of the petitioner, my lord. And now they are giving them, earlier he was given additional charge on the guys that my block has so many schools. Now, my lord, by the impugned order, they are giving the entire block to the respondent number 7.
This is also issued by the deputy commissioner.
Yes, my lord, issued. That has been also challenged, my lord.
Oh, this is also under challenge.
Under.
The basic thing is that this is the exigency of service transfer had been made. Not only transfer, the change of zone, that one place to other.
Is it public interest?
Yes, public interest is Lordship will see the page number 22, very first line. In pursuance the mission director Samagra Shiksha wide number so and so dated 9/8/2023. There is an order giving the power to the particular officer and the district commissioner come chairman. He happens to be in a district, the head of the district of the SSA. He gives an order for changing of this post from one to other. So there is no infirmity. Only thing is that if Lordship turns to page number 16, there is this is the original copy, my lord. There is a
page number
16. Lordship will see the mission director knows these are the page number 16, order dated 9/8/23. Here the mission director has already delegated the power to district mission coordinator, who is below the district commissioner, to make all the accidents or the transfer arrangements of all these arrangements of blockwise. And the district commissioner happens to be the head of the district. So he has the power and jurisdiction to rearrange all these activities, who will be posted in what post, how the public service had to be done. So there is no infirmity in the order. And exigency of public service, this person has been removed, someone has been brought in, and by now the other person may have joined. It is order dated 9/12/2024.
Have you joined to the place?
No, not yet, my lord.
Why?
My lord, kindly see.
Why you have not joined?
This is, my lord, that Annexure 6 is passed when, my lord? On, my lord, 11/6/2024. That is supersession to the earlier orders, my lord. That was passed on 11/6/2024.
What is it?
This order was passed, my lord.
Okay.
Prior to that, my lord, kindly come at page 90.
Yes.
It has been brought to the notice of the undersigned that the district mission coordinator sometimes transfer block level officials of SSA from one block to another block without prior approval of the mission director, SSA, Assam. It is hereby ordered that no block officials will be transferred attached to any block without approval of the mission director, SSA, Assam.
You're correct.
Thereafter, Milan, thereafter, this type of transfer is going on.
No, read your order, that the first line.
My lord.
This is in pursuance of the mission director.
Of course, my lord, that was prior to passing of that order of, my lord, at Annexure 6.
9/12/2024 order, page 22.
Yes, my lord. He exercised the order of what? Passing of this order, my lord. That prior to that order was passed, that power was given prior to passing of this order, my lord. At page 21. That was passed on, my lord, 11/6/2024, my lord.
Fine, 11/6/2024, that order was passed.
On that day,
Now, when the impugned order was passed on 9/12/2024,
my lord,
that was passed on the direction of the mission director.
that earlier, that
I'm talking about the recent one, 9/12.
Yes, my lord.
Page 22.
My lord. My lord, earlier he was given implied power, my lord. Implied power. That too taking prior approval of the mission director. But that was extinguished by the order that at page 21, my lord. The total power is given to the mission director.
Correct.
Total power is given to the mission director. And in this order itself, there was nothing is written, my lord, that this was done pursuant to the approval of the mission director.
It is there in the order. The first line, read it.
That order was passed pursuant to prior to, my lord, passing of order dated 11/6/24, my lord.
9/12/2024, after the order of 11/6/2024 was
Yes, my lord, that order has been extinguished, my lord.
Read the first line of that order, 9/12/2024.
9/12/2024, my lord. Yes. In pursuance of the mission director, Samagra Shiksha, order by number so and so, dated so and so.
So
this order is no longer remain, my lord.
You make a representation. You file a representation.
Yes,
for
my
the
lord.
mission director.
My lord.
All right.
Till then, I will not be.
No, I'm not interfering with it. I see nothing wrong in this one. If I'm just giving you a time to file a representation before mission director will consider it and dispose of within 2 weeks.
Lord.
All right.
Within that period, I may be, my lord.
Heard, Mr.
S. Sahul.
Sahul, under counsel for the petitioner. Also heard Mr. MS S. Chutial, and Standing Council, Elementary Education Department. For the respondents 1 and 2, and Mr. S. Boral, and Standing Council. SSA for the respondents 3, 4, and 5. Stop. Para. while the petitioner was working as a junior engineer under the Ramakrishna Nagar block within the Ahom Sarva Shiksha Abhiyan mission, Karimganj, the district commissioner cum chairman Shrubhumi district oblique respondent number 3, no, respondent number 4
meters.
passed in order on 9/12/2024, by which the petitioner was entrusted to look after the matters related to civil works under the North Karimganj block, and the respondent number 7 was entrusted to look after the civil works with regard to the Ramakrishna Nagar block. Stop. The case of the petitioner is that the district commissioner cum chairman Shrubhumi district has does not have the jurisdiction to pass the order, inasmuch as the respondent number 3 oblique mission director SSA had already issued an order on 11/6/2024, whereby the issued an order on 11/6/2024 pursuant to the resolution of the 15th Executive Committee meeting, which was held on 4th May 2024, and which was also subsequently approved by the Government of Assam, Department of School Education, that the mission director SSA is the engaging oblique controlling authority and disciplinary authority for the post of electronic data processor of district and block, junior engineer, resource person, and LDA accountant and block assistant. Learned counsel for the petitioner therefore submits that in view of the order dated 11/6/2024, the district commissioner, the respondent number 4, has no jurisdiction to issue the order dated 9/12/2024. Stop. Being aggrieved, the present writ petition. Para. After hearing the parties, learned counsel for the parties, this writ petition is disposed of, directing the petitioner to file a representation before the mission director SSA oblique respondent number 3 within a period of 1 week from today. Stop. Thereafter, on receipt of the representation, the respondent number 3 shall consider the same and dispose of the same by a speaking order and in accordance with law within a period of 2 weeks thereafter. Stop. With the above observations and directions, writ petition is disposed of.
37.
May it please your lordship. My petitioner before your lordship, my lord, is a governing body of a B.Ed college, namely my lord, Dr. Sarvul Radhakrishnan Research Institute and Training Research Institute, my lord.
Yes.
Then, my lord, what happened, my lord? In this case, my lord, the NCT had issued a public notice, my lord, on my lord 9 September 2024, page 55, my lord. Page 55, my lord. Hereby asking the research educational institutions, my lord, to submit some report, my lord, performance appraisal report, my lord, online. And for that purpose, my lord, the B.Ed college needs some documents from its sponsoring body, my lord, namely Project Samata Educational Society, my lord. On receiving this, however, this notification was extended, my lord, time was extended, my lord. On receiving this, my lord, kindly come to page 57, my lord. The principal of the said B.Ed College, my lord, had submitted a representation before the sponsoring body, my lord, on 21/10/2024, page 57, my lord.
Yes.
Requesting the President Secretary of the sponsoring body, my lord, for furnishing the details of the parent body society for filling up an online submission of performance appraisal report for the year 2021-22 and 22-23 to NCTE, my lord. Thereafter, my lord, the petitioner had again, the principal of the said B.Ed College, my lord, had again submitted another representation, my lord, page 61, my lord, a reminder, my lord, on 4/11/2024, my lord, to that sponsoring body, my lord. Now, my lord, despite of repeated communication by the principal, my lord, the sponsoring body is not furnishing that required particulars, my lord. And now, my lord, at present, what happened, my lord? Kindly come to page 66, my lord, Annex I, my lord. This is the last communication issued by the NCTE, my lord, public notice, my lord.
Page
66, my lord. Last
Yes.
page. Here, my lord, public notice, my lord. Please refer to the public notice dated 9/9/2024 and 7/11/2024 regarding online submission of the performance appraisal report by the teachers educational institutions on NCT portal, so and so, for the academic session 2021-22 and 23-23 from 9/9/24 to 10/11/24 till 11:59 p.m. After due consideration of the representations received from various stakeholders.
Okay. Then
Now, my lord, what happened? This last date has been given as 21/12/2024. Last date for submission of the online portal, my lord, is given third paragraph, my lord. Therefore, the teachers educational institutions which have not filled up performance appraisal report till date are hereby advised to file par on or before 31/12/2024. Now, my lord, here is my lord, petitioner institution in a awkward position, my lord. What happened, my lord? Despite of repeated request by the principal, my lord, to the project Samata, my lord, that is pushing body, they are not furnishing the copy, my lord. Some three particulars, my lord, that I have already annexed, my lord, but they have needed, my lord.
what are the particulars that you require?
My lord, finally come to page 59, my lord. Page 59, my lord. That is serial number 3, 4, and 5, my lord. That tick mark, my lord, that is 3, 4, 5, my lord. Those were required from the parent body, my lord, that is sponsoring body. Now, due to the lack of these documents, my lord, the petitioners are not able to submit their online application. Now, the petitioners are in apprehension that the future of the large students, my lord, they will be in dark, my lord, if they could not file it before 31/12, my lord. So, my lord,
Your lordship may kindly peruse the prayer of the petitioner. They are rating the nature of mandamus. Lordship got it. Page 19,
19,
my lord. He should be directing the president secretary of the project Chotoma
Your society.
Society, my lord, to furnish the required documents so as to enable the principal Chobopoli Radhakrishnan Training Institute is in Nalbari for filling up the online performance appraisal report. That is totally, my lord, whether it is maintainable, my lord.
what I am submitting, my lord, kindly see other prayers, my lord. My interim prayer is also there, my lord. What happened, my lord? Not only private, but the registered
since 31/12 is the last date. Let them file their performance appraisal report, and it's a all-India circulation, my lord.
that is why, my lord. That is why, my lord, petitioners in
What
apprehension, my lord,
action, my lord?
if they could not file, my lord, because it is up to the my lord, sponsoring body, my lord, who is to furnish some documents, my lord. So, my lord, if they could not furnish, so, my lord, my prayer is that, my lord, notice may be issued, no problem, my lord. But in the meantime, my lord, if they cannot file, my lord, within that stipulated time, my lord, no coercive action may be taken, my lord. Otherwise, my lord, the future of those students, my lord, B.Ed students, my
What
lord,
type of coercive action do you expect?
my lord, they can, my lord, cancel the recognition also, my lord.
31/12 is the last date, my lord. It may be extended to further, maybe. It's all
That
India.
is only
all India, my
coercive
lord.
action, my lord.
And what type of coercive action? Whether they have informed the NCT, my lord, there is nothing about whisper about the
They are difficulties.
You're doing
These are
nothing.
private institutions.
I have
Your last representation was
To the secretary, my lord, that is
To the secretary, yes, my lord.
president secretary of the trust, my lord. It's a totally private.
it was on 4/11/2024.
yes, my lord. 411 and yes, my lord. Last
After that, you're doing nothing.
no, my lord. Thereafter, my lord, some communications were going on, my lord, but they have not yet submitted, my lord.
What
Now, my lord,
communications?
my lord, verbal communications are going on, my lord. Some people have already approached, my lord.
Itself, read itself not maintainable, my lord. In my humble submission, my lord.
My lord, here, my lord, that is a registered society, my lord. And it is controlling, my lord, and sponsoring body, my lord.
That we will come to know only after the society is served notice.
My lord,
After
that is why, my
we'll
lord,
see.
there, let me notice be issued, my lord, no problem, my lord. But only my prayer is that till,
What type of a coercive action do you expect?
No, my lord.
my lord, if they assume, my lord, no problem, my lord. Because my apprehension that, my lord, if since, my lord, that date had been extended till 31st December, my lord. So, my apprehension, my genuine apprehension, my lord.
No. How about the maintainability of the writ petition?
My lord,
Its petition itself not maintainable.
no, my lord, that is the registered society, my lord. Under
How do
society
we know
registration
that?
act.
How do we know that?
Because, my lord, I have stated already, registered society, my lord, and there, in the paragraph, I have stated, my lord, the registered property society. my
Statement
lord.
is not, but how do you know that it is a registered society?
My
Where
lord,
is
I have
the, where is
stated,
the
my lord,
registration certificate?
that I can furnish, my lord. But it is a registered society, my lord. I have
What do you mean you can furnish? You should have annexed the thing in the first place when you're asking for mandamus.
just give me some time, my lord. I'm furnishing it.
See, there are many councils waiting.
My
Today
lord,
is
my
the
lord.
second last day.
I'm really
We have
sorry.
a reference today.
My
I'm
lord,
not wasting time.
my lord, I have already, my lord, stated, my lord, in
It
my
comes to
paragraph, my lord.
application, my lord. And he, in the meantime, he will file the registration.
You file the registration certificate. After that, we'll take. Otherwise, the maintainability of this
Yes,
petition is
definitely.
My
under
lord,
question.
kindly, after, my lord, paragraph 2, my lord, kindly see, my lord.
Paragraph 2, I've seen it. Where's the document? List after doing the vacation.
After application, my lord. 48.
My lord. My lord, can be taken after some time, my lord.
Yes.
Merit. This is regarding managing committee or school, high school. And it was a Provincial school, and last, after experience the last committee, the unsuperior school issued a notice, annexer 1 page 13, to constitute a new assembly. Then what happened, headmaster issued a notice for the only 2 villages. I am coming to that, headmaster notice, page 16. And the reference notice was issued to only 2 villages, notice board of Moko Madrasa and notice board of Madrasa, Romani Madrasa, only 2 schools, 2 villages, and school Miller, high school is Madrasa high school in a particular village Miller. So what happened Miller, but the respondent number 8, who is the president of the SMC Miller, who has been selected from another district, not from the local district, local village Miller, and that is only my grievance Miller. I approached the IS Miller.
When was the respondent selected?
He was Milord, he is a approved Milord, annexer Milord.
Page?
Page is Milord. Page Milord 19. Serial number Milord on. In can see. Rashid al Islam. He is Milord, President Milord, President of the SMDC. As illustrative body.
Meeting dated 18/2/2023.
My lord.
Now we are in the end of 24, lord.
2 years passed, yes. That is admitted, Milord. In the meantime, I was a candidate for the same position. I am a local, I was not given, and he was given, Milord. So we had, of course,
Why are coming after 2 years?
Actually, Milord, he is from the same local, but he did not took any information. Lastly, Milord, he was taking all information and found that he is from outside, Milord, another district. I am in the same district.
Where's where have you stated with regard to the delay in approaching this court?
Delay, my lord, I have not issued
No,
on that.
there
I
no
will-
You file an affidavit.
Yes, yes.
Mr. The petitioner shall file an affidavit explaining the delay in approaching this court. List after 2 weeks.
39.
May I please? My lord, may I please, my lord? My lord, your lordship may kindly see page 23, my lord. I am the second senior most teacher in the school, my lord. The serial number 2. What happened? Serial number, yes, serial number 2, I am the
Moon.
second, yes.
Huh.
Moon Kumar type, my lord.
Huh.
What happened on 30/11/2026, my lord, 2024, on 30/11, the earlier headmaster retired. As the first, my lord, the senior most teacher, my lord, the Gita Mani Dr. Bora, she refused to accept the, my lord, search. I was given search on that day, and I was consuming. But now, my lord, the serial number 4 in the same list, Jadov Bhuya, who is appointed on 10/8/2009, has been, my lord, given search by the DO at page 21. This is the impugn order, my lord.
Page 21.
Yes, my lord. By this order, my lord, the serial respondent number 6, who is in the serial number 4 in the, my lord, seniority list, he have been given search, allowed to take, my lord, continue search. So I am already in search, my lord. So at this stage, my lord, your lordship may stay this, my lord, because
yes, Fukan.
In any school, my lord, there is no other option except this seniority, my lord.
Lordship, this stage, since it's come for the motion, my lord, notice may go, my lord, in the
No,
meantime.
I'm not issuing notice. I'll ask you to take instructions, and on the next day, I'm considering the interim order.
My lord, my lord.
Because in view of the seniority list, it appears petitioner.
No, my lord, your
the
lordship-
senior most.
My lord, and by that time, my lord, the private respondent also will.
My lord, I pray for stay because I'm in search, but otherwise I will have to hand over search. my lord.
Oh, you're still in charge?
Yes, my lord. From 30, I'm in
That
charge.
instructions have to get whether he's in.
No,
charge or
that is my lord, search and our report I have annexed, my lord. Search, taken search, my lord.
Mr. J.
annex the
Bayang,
detail.
then counsel for the petitioner. Issue notice. Mr. A. Fukan, then
For 1
standing
to 5.
counsel, elementary education, appeals correspondence 1 to 5. Huh? Extra copies. Petitioner to take steps for service of notice on the respondent number 6 by registered post AD within 1 week from today. Stop. List after 4 weeks. Stop. In the interim, the order dated 13/12/2024 issued by the district in charge district elementary education officer Lakhimpur, allowing the respondent number 6 to hold the current charge of headmaster written bracket in charge of the Sowansiri
Sevas from ME school.
Sivasharam ME school shall remain suspended till the next suitable.
Item 40.
My lord, hearing this case, my lord, we have the limited prayer, my lord. Kindly see, my lord, page 50, my lord. This is the communication made by the Mizoram University to the Higher Education Department, my lord. Regarding, my lord, the settlement of the, in respect of the petitioner regarding, my lord, pensionary benefit, my lord, for processed and finalized, my lord. And this letter is pending before the Higher Education Department, my lord. We pray, petitioner prayed before your lordship, my lord, for disposal of this letter, my lord, within a 4
Higher
weeks, my lord.
education does.
That can be disposal within a period of
4 weeks, my lord.
yes. This is the second round of litigation.
This is the second round of litigation, my lord. Earlier order is at page 46, my lord.
Why does the Mizoram Authority, University have to, does it come under the Assam?
No, my lord.
What had happened, this petitioner was earlier in the under Assam government.
Under Assam.
Thereafter, he got a post reader in Mizoram University. Then his CPF account has been converted into a GPF. Yes.
Heard Mr. D.K. Roy, learned counsel for the petition. Also heard Mr. S. Das, learned standing counsel, higher education for the respondents.
One,
One,
two,
two,
one and two.
one and two. Stop. MS RM Barwa, learned standing counsel, finance for the respondent number 3. Stop. And Mr. R.K. Talukta, learned standing counsel, principal accountant general, Assam. Stop. Para. The petitioner was initially appointed as a lecturer in the Department of English at Tihu College, Tihu, by an order dated 25/8/1984. And the service of the petitioner was regularized with effect from 1/1/1986. Stop. After regularization of the service of the petitioner, as no GPF account was opened, the petitioner approached this court by filing WBC number 2786/2021, which was disposed of by an order dated 25/4/2024, recording the submission of the Learned Standing Council, Accountant General, correct, that the GPF account of the petitioner
Already open.
was already opened, bearing number CD-7491. Stop. Stop. Para. The present writ petition has been filed by the petitioner that after his GPF account was opened, the petitioner submitted his GPF account number before the concerned authorities.
Yes, sir.
For finalizing the process for getting pension to the petitioner, as the petitioner is due to retire on 30/4/2025. Stop. The joint register within bracket establishment of the Mizoram University by a communication dated 5th June 2024, addressed to the Director Higher Education, Assam, wrote on the subject of permanent observation of the petitioner in the Department of English and Cultural Studies, Mizoram University, and requesting for processing the processing and finalizing the for the benefits of gratuity, pension, leave engagement, along with GPF stuff. The grievance of the petitioner is that despite the letter dated 5th June 2024, written by the Registrar of the Mizoram University, the Director of Higher Education, Assam, is yet to take a call on the said letter. Stop. But considering the short issue involved in the writ petition, in this writ petition, considering the short issue involved, this writ petition is disposed of, directing the Director of Higher Education, Assam, to dispose of the letter dated 5 June 2024, written by the Joint Registrar within bracket ESGT, Mizoram University, within a period of 1 month. 1 month from the date of receipt of a copy of the order of this court.
Obliged, Mike.
Which petition is disposed of.
Item 33.
1 minute.
Item 41 and 42. Index, yeah, lordship here, Leonard, he will appear, he is on legs in court number 1 right now. He was, otherwise he was free, lordship. Right now he is on legs court number 1. He has specifically requested me that he will appear in this case. So tomorrow, lordship, any other court tomorrow, lordship. Today we don't
Some
have-
urgency is involved in the matter.
Our information is they are going to get their letters on 23rd of this one. That is our information. If that happens and the clauses remain, we are immediately reverted to what they gave us in 20. And our salary which we are drawing will go down. That should not happen, Miller, on regular action.
Tomorrow, lordship. Tomorrow,
With regarding to the advertisement, that clause, 1 and 2, I think.
Yes, I am only on one. The others will take care of
Eddie
itself.
will address that issue. Yes, that we have instruction. Eddie will, learned advocate.
No,
will
no,
address it.
he may.
Tomorrow.
I think it's just pure logic.
Absolutely.
That once the advertisement concludes, then after that they can apply that clause. But till the advertisement concludes, I mean the process of advertisement is concluded, they will keep on receiving what salary they will get. That's
Let it take up tomorrow, lordship. Because I have specific
tomorrow is
instruction
the
from
last day.
I
And
don't
then I'll
know,
see.
because this is a very unreasonable prayer. You have given in 20 the scale. We have got the salary, say at 5,000. Now they will regularize, our salary will come down by $1,000. The difference will be about 4,000 or 5,000 million. And this is a punishment. Your increment, our increments will be lost. And
because I have a agreement, lordship. Eddie has directed that he will appear and
no,
address
no,
this.
that direction is your business. We are not concerned with that.
Okay, we'll list it tomorrow as the first item.
Yes.
Heard Mr. BK Goswami, London Senior Counsel, assisted by Mr. DB Bora, BB Bora, London Counsel for the petitioner. On request made on behalf of Advocate General Assam.
That can be written on my behalf, lordship. Mayor.
No, yesterday also you said the same thing. So
No, I can't understand all
list the matter again on give tomorrow's date as first item.
deeply.
So item 33, there's only one item left, lordship.
Yes.
Can it be, lordship, immediately after vacation 7 or 9, lordship? Your record was called for, lordship, perhaps from State Open University.
Admission. Okay.
7 or 9.
On request made by the parties, list the matter on
7. Lordship.
9.
9.
Oh, nine, there are 74 cases.
Seven, then not
Seven.
obliged.